ಓಕೆ, ಮೆಂಬರ್ಸ್ ಇದ್ರಿ, ಜಡ್ಜಸ್ ಇದ್ರಿ ಅನ್ನ. ಓಕೆ, ರೈಟ್.
His promotion, nominal proceeding has been continuing for the last 10 years. No disciplinary proceeding, no suspension. He was allowed to retire, but the legitimate benefit was denied. Now Miller get retired. Miller directed the court below to conclude the proceeding by June 2025, December 2025, criminal proceeding. But Miller, the other thing is that a man who was never subject to disciplinary proceeding, any suspension, that he has been denied his legitimate right.
The High Court's direction is already there after considering everything.
That is other proceeding. Six witnesses.
When did he retire?
May 2025. And I filed before that. This is second ground litigation. I was kind enough directly to wait. I waited, Miller. I am taking a chance. I know, Miller, your lordship's insurmountable difficulties. I know that I cannot, Miller, succeed in one action. But I am trying to pursue your lordship, Miller, if something happens.
This hearing matters. See, we have only one day.
Only
one day.
But he is, Miller,
and you will be surprised that we had called so many cases. Nobody is appearing.
Your lordship kindly, since your lordship is from the bar, your lordship knows, Miller, the climate. I have to, Miller, do certain things, Miller.
Yes, we know.
I at least, Miller, certain rights your lordship have conferred us to disturb your lordship.
Let us see how things progress today in the next week.
Matter have several locations have mentioned for reconstruction. The Registrar General has been sent the report, lordship, before your lordship.
You place it in the chamber, not here. You place it in the chamber. We'll see.
May I come back tomorrow, lordship?
Yes.
Great.
No, you come back on Monday.
My lord, I am praying for this filing supplementary affidavit in the matter of Major Manya Ganguly versus Union of India, WPCT 174, my lord.
Yes.
For listing and filing supplementary affidavit, my lord.
My lord, if I may, my lord, in the matter, my lord,
Yeah.
am I audible? My lord, the matter is for today's item number 6, my lord. It is for the admission hearing, but my lord,
6.
yes, my lord. But
Today?
yes, my lord. But my lord, during this period, we have filed this writ petition. There has been some subsequent developments has happened, which
So
is
you
very
can't
much.
wait for 5 cases.
No, my lord, we are mentioning that that
Let
there
it
is
be
like,
taken up. We'll see who's appearing for both sides are there or not. Let us see.
my lord,
5
there is also
cases.
the affidavit of service also, my lord. So that's why the issue is
So
there, my
let's
lord.
see if it is on the list at 6. Why you have to mention right now? Yes.
No, much,
Yes.
my lord.
Call.
Item number 1.
To appear on behalf of respondent number 2 and 3.
Sir, good morning, sir. Yeah, am I audible, sir?
Yes.
Sir. I am the
In the earlier occasion, my lord, there was a direction for filing of my lord, opposition. My learned friend has filed his reply, although, my lord, may I file my opposition?
The opposition was already served.
Yes, sir. I have received opposition, sir. Sir, may I start, sir?
Just a minute.
No, sir.
Yes.
Sir. Thank you, sir. Sir, this matter is regarding premature repatriation, sir. The main allegation against me is I am sending representations or grievances directly to the higher officers, which has been mentioned at page number 65 of the writ petition, sir. Page number 65, sir. They have mentioned 4 direct communications to the higher authorities without through proper channel. Para number 14. 65, sir. Page number. This is the reply which they have been filed before the CAT. Para number 14, sir. Third line. Did you got, sir?
Where is the repatriation order?
Repatriation order is before repatriation order, they have made some allegations against me, sir. In addition to the concocted allegations, sir. Page number. Sir, page number 44, sir, of the petition. Page number 44 of the petition, second para, sir. Sir. They have made only 3 allegations, sir. First one is, I am ignoring the verbal and written directions of the superior officers. This is the main grievance, sir. The second one is complaints and representations sending directly to the higher authorities. And third one is some of the communications which I made are offensive, sir. These are the allegations, sir. But in third para, they have mentioned, considering his repeated misconduct and failure to improve his conduct, it has become imperative for this tribunal to repatriate him prematurely. They have admitted themselves this is the misconduct, but they have not conducted any disciplinary inquiry. Even they have not issued show cause notice to me. This is the law laid down against the Honorable Supreme Court in the case of Parshottamlal Dhingra versus Union of India, sir. I have mentioned in my writ petition, sir, on the last occasion also, I have given one case law, sir, in which they have mentioned, sir, kindly see the cause case law, sir. On the last occasion, I have given to the corner bench of the tribunal. Page number
Last
9.
occasion, it was taken up by the other bench.
Yes, sir. Page number 9, sir. Page number 9.
9 of
9 of case law, sir. Case laws. Last time I have given.
you have given a compilation.
Sir, compilation, sir. Yes, sir. नहीं, ये तो वो पेज नंबर 16 में भी है रिट पिटिशन. डिड यू गेट, सर? Compilation, sir. Page number 9 at para number 35, sir. Page number 9 at para number 35. In Parshottamlal Dhingra. It has been mentioned in my writ petition also, sir, at page number 16. Have you got it, sir?
Yes, yes. Let us go through.
Para 35 is the relevant para, sir. Para 35 is the relevant, sir. Sir, they have admitted themselves this is the misconduct, but not conducted any inquiry, sir, and also not issued any show cause notice, sir, which attracts the judgment of the Honorable Supreme Court, Constitutional Bench decision, sir, Parshottam Dingra. Page number
Yes,
9.
all right. Which other judgment?
Yes, sir. Page number 9. Have you got it, sir?
Yes, we have gone through. Which other judgment? Tell us.
Sir, uh, in this judgment, it has categorically stated that when an appointment is made for a specific period, unless any disciplinary proceeding is initiated, a person will be entitled to hold the said post. Sir, my
So we
period.
are asking you which other judgment we have gone through. Please
Yes,
tell
sir.
us which other.
Yes, sir. Yes, sir. There are 2-3 judgments, sir.
We have heard you are relying on paragraph 35. We have gone through. Now tell us which other judgment.
Sir, sir. Page number 14, sir. Page number 14 of compilation. This is the Jharkhand High Court judgment, sir. Para number 13 and 14 are relevant, sir. Para 13 and 14.
So it is the same issue, same point, yes.
Sir, same point, sir.
Yes,
And also, page number 15, sir, it has been, there is a substantial question of law has been framed by the Jharkhand High Court, sir. Para number 18 and 19. The same issue, sir. Page number 15, para 18 and 19.
yes, we have seen. Now what?
Sir, one more judgment, sir. Ashok Kumar Rathirali Patel Supreme Court judgment, sir.
Yes.
Page number 21, sir. My appointment is not transfer on deputation, sir. Appointment is appointment on deputation, sir. My deputation is not on transfer on deputation. My deputation is appointment on deputation, sir. Therefore, I have vested right to continue till completion of the period, sir. Completion of the entire period of 3 years. Page number 21, sir. The Ashok Kumar Rathirali Patel in the judgment.
Where it says you have indefeasible right to continue.
Yes, sir. But it has not been placed. Thereafter, I found it, sir. Allahabad High Court, sir. Allahabad High Court.
No. See, you have given a compilation of the apex court judgments. You
Sir,
said in this Ashok Kumar Rathilal Patel,
sir.
the apex court has held that you have indefeasible right to continue. Where
Yes,
is
sir.
that? Let us see.
Sir. Para number, page number 21, para 12, sir.
So let us see where it says indefeasible right to continue. Please, read it.
Right. Sir, indefeasible right. One minute, sir. However, I am reading the para number 12. However, the aforesaid principle cannot be made applicable in the matter of appointment and deputation.
Yes.
My deputation is appointment and deputation, sir. In such case, for appointment and deputation in the services of state or organization or state within the meaning of Article 12 of the Constitution of India, the provisions of Article 14 and 16 are to be followed. No person can be discriminated, nor it is open to the appointing authority to act arbitrarily or to pass any order in violation of Article 14 of the Constitution of India. A person who applies for appointment on deputation has indefeasible right to be treated fairly and equally.
That is correct. No indefeasible right to continue. A right to be treated fairly, and that is, of course, that is available to everyone. Whether deputationist or not deputationist, everybody has to be treated as fairly.
Sir. Recently, I have not placed that judgment, sir. Recently, I found from internet, sir, the Allahabad High Court at bench at Lucknow in special appeal defective number 61 of 2022, date of order. At the head note itself, it has been mentioned, in case of appointment on deputation, employer cannot claim employee has no right to continue till completion of deputation.
That you have already given 2 judgments already. You have given us 2 judgments. Why?
Okay, sir. Okay, sir.
First and second, you have cited on this point only that once it is a tenure deputation, it cannot be abruptly ended. That is your submission relying on these judgments.
Sir.
Unless it has a specific reason. It cannot be done in a mala fide way. That is what you are trying to say. Yes.
Repatriation, premature repatriation can be done only on 2 grounds, sir. One is unsuitability, and second one is unsatisfactory performance. But they have not placed any document on record to show my performance is not satisfactory and also I am not suitable. That's why their stand is not to be considered, sir.
Okay.
Office memorandum, sir. Office memorandum, page number 23, sir. Compilation. Para number 3, sir. para number 3. They have made allegations against me is I am sending representations directly to the higher authorities. This is applicable, sir. Existing instructions clearly provide that representations on service matters should be forwarded through proper channel. Every application or every grievance I have sent through proper channels, sir. I want to show. I want to show the grievance. The main foundation is to repatriate me is I have made grievance, sir, against petition at page number 35, sir.
No, before we go to page 35,
Sir.
page 44 is the repatriation order.
Page number.
It does not refer to any specific communication written by you.
Page number 44, sir.
Yes, you have placed it. We asked you, you had placed page 44 that it is the repatriation order.
Yes, sir. Yes, sir. Yes, sir.
It does not refer to any specific communication. It only says that you are doing this. You are
Yes,
not,
sir.
according to them, you are not following the directions of
Directions,
your
sir.
seniors. You are
yes, sir.
not maintaining the decorum, and you are shooting off representations directly to the higher authority.
Authorities, sir.
But they have not referred to any detail as to what is that representation.
They have not mentioned any reference in this letter, sir.
So therefore, where is the question of looking into which representation they are alleging?
Yes, sir. First, I want to show the, sir. I want to
Yes.
show the page number 35. This is the grievance against the raised registrar in charge, sir. Page number 35. My writ petition, sir. Page number 35, sir. Page number 35, sir. I have addressed to the Honorable Chairman that was sent through proper channel, sir. I have specifically mentioned through Registrar in charge Regional Bench, Kolkata. Sir, your good self may kindly see the bottom of the page. I have taken seal, signature and date from the registry. Bottom of the page, your good self may kindly see. This was routed through proper channel, sir.
Yes.
Page number 41, sir. 2 minutes I will be completed my argument, sir.
No,
Page
no,
number 40.
we have understood what we are
Sir.
telling you is
Sir.
you can show us 2, 3, 5 representations which you have made through proper channel or to the competent authority.
Yes, sir. Yes, sir.
But we
Sir.
don't know whether they are talking about these or they are talking about something else, because they have not mentioned where is that representation, which is that representation which you have directly written to any superior. They have only
sir.
made a allegation that this you are doing this.
Those are
Yeah.
concocted allegations, sir.
So therefore, we don't know. Let's see which
sir.
if they have they asserted in their reply which is the
sir.
representation which was directly shot off to the higher authorities.
Sir, page
Have
number
they?
one more minute, sir. Page number 41, sir.
Yes.
This is the circular issued by the respondent, sir.
Yes.
Second para, sir. Page number 41. Second para. Such unhealthy practice is adversely affecting the functioning of the organization. Hence, this needs to be restricted. Otherwise, disciplinary action will be initiated against the officer or official, sir. They have not taken any disciplinary action against me, sir. Even they have not issued any show cause notice, sir.
Yes.
Sir. If I have sent direct representations for a moment, it is correct. Then the rule 3133 of the CCS Conduct Rules 1964 will attract, sir. If I send directly to the higher authorities, they cannot terminate my deputation, sir. And one more I want to say, sir, they have issued termination notice for 3 months, sir. That has not been approved by the appointing authority, sir. My appointing authority is Honorable Raksha Mantri. Page number 44, sir, your good self has seen. Page number 44, they have made delegations. This is the 43, they have, on the basis of 44, they have issued page number 43. They have mentioned only approval of the competent authority, but my appointing authority is Honorable Raksha Mantri, sir. But they have issued with the approval of the chairman termination notice, which is also violation of the recruitment rules, sir.
Yes.
Let them speak how many I have been sent directly to the higher authorities, sir. Sir, one more submission, sir, please. Sir, only one more submission, sir. I have applied leave, sir. I have applied leave 10 days before repatriating me. Before repatriating me, 10 days before, I have applied leave. But my leave has been granted. Page number 53, sir. Page number 53. Sir, column number 8. I have specifically written grounds to celebrate Sankranti festival with my family members at my hometown, which is famous festival in South India. On that ground, I went to my native place, sir. When I was at my hometown, they have issued relieving order, sir. Relieving order. But as a gazetted officer, they cannot relieve me. Page number 96, sir. How to transfer of charge? It has been mentioned. Page number 96. They have violated rule 255 of the GFR rules 2005.
Which rule?
255, sir. 255 of General Financial Rule 2005. Page number 96, sir. May I read, sir? Page number 96. Last, sir. Rule 255. 1. A report of transfer of a gazetted government servant duly made in form GFR 33 and signed by both the relieved and relieving government servants shall be sent on the same day to the head of the department or other controlling officers. Sir, I want to say is at the time of transfer of charge, relieved officer and also relieving officer signatures are must. But in my case, whenever I was at my hometown, they have issued relieving order to my email. Therefore, they have clearly violated Rule 255, sir. One of the judgment in Jammu and Kashmir High Court, it has been specifically mentioned, transfer of charge should be made at headquarter itself. They cannot send through email or somewhere else, sir. This rule is also they have violated, sir. Now let them speak.
So far as my lord, the reply part is concerned, my lord, probably my lord, my learned friend has handed over a copy of my lord, compilation of judgment, which I do not have. But this, my lord, I'll just give reply subject to your lordship's kind convenience on some.
No, what don't you have? If you don't have, then why don't you say so at the beginning? Unnecessarily, we are hearing.
Your lordship was hearing, I would.
You should have said that there is something which is not served.
And
What
my lord,
is
one-
not served?
my lord, one more thing.
No, first tell us what is not served, then you may proceed.
Lord, the copy of the compilation of judgments.
That's not required. These are reported judgments.
But the reported, my lord, he has not mentioned my lord, the citations. I'll just
Sir, I have mentioned, sir. He is wrong. What he said is wrong, sir. Page number 16 and 17. Please kindly see writ petition.
Yes. Let's see.
No. Please see page number 16 and 17. I have mentioned Parshottamlal Dingra case. It is specifically says if the employee is appointed for a term without conducting inquiry, he cannot be terminated.
That is the proposition he has relied upon the judgment.
I'll do that. My lordship, kindly consider two things. My lord, today I am ready, my lord, I can argue. My lord, the problem is, my lord, the entire pleadings, my lord, should be brought on record before this honorable court. My lord, he has filed his petition, my lord, without annexing my opposition. My rejoinder has to be placed before your lordship, my lord.
Your reply before the tribunal.
Yes, it is not here, my lord.
He was referring to your reply. What do you mean is not?
It should be brought on record, my lord.
No, it is there.
Lordship kindly sees page 61.
Yes, that is your reply.
But page 61, lordship kindly considers
Yes.
up to page 80, my lord, without
Yes.
any annexure.
Huh?
Without any annexure.
Then who prevented you from filing it, sir? You were allowed opportunity long back.
But I covered, my lord, everything in my.
Then why are you raising this issue again?
But the entire pleadings are not.
We don't know. You were allowed the opportunity. You read the last order.
Let me proceed that on that basis.
Don't raise
Sir,
unnecessary issues.
Sir, no,
Please,
sir.
please wait. Let him. Yes.
Lordship may kindly have a look to, my lord, the order impute.
Yes.
But at page page 81 it starts. Page 82 onwards, lordship kindly sees what is his prayer about. And my lord, I'll just show, my lord, the relevant part of the order. My lord, my lord, sum and substance of his prayer, my lord, he challenged, my lord, that premature repatriation order, my lord, 3rd of October and, my lord, 24th of September. 24th of September, your lordship has already looked at it. My lord, may I just place 3rd of October, my lord, again, my lord, at page 43. Because this is, my lord, the enclosure of, my lord, annexure P8.
Yes, we have seen that also. He has just placed both these dots. Yes.
But the reasons shown was there is due to administrative reasons mentioned in its letter number so and so dated 24th of September. And my lord, the notice period of 90 days also, my lord, given. That is, my lord, the only requirement here.
No, sir. It is very wrong,
This
sir.
is not the way, please. Yes.
Now, my lord, the 90 days period, my lord, we have given him.
Yes.
Now, lordship kindly sees, my lord, the administrative action deemed appropriate. That was the, my lord, satisfaction recorded at paragraph 3. Now, lordship kindly comes back, my lord, once again, my lord, to 44. Your lordship, my lord, put a query, my lord, with regard to, my lord, what were those communications, my lord, we didn't indicate. Truly, my lord, it is not indicated here, my lord, so far as, my lord, the language is concerned, my lord, they have only relied on the memo of, my lord, 17th of June 2010. And, my lord, the departmental circular, my lord, dated 4th of October 22. My lord, Lordship may kindly come to my opposition for a moment. My lord, we have indicated in our opposition what are those, my lord, emails and complaints he has, my lord, forwarded, my lord, directly, my lord, to the Delhi office, violating, my lord, the departmental circular as well as, my lord, the office memorandum, my lord, of 2010. Now, my lord, if your lordship kindly, my lord, comes to, my lord, the affidavit in opposition for a moment. Kindly come to, my lord, the annexure, page 30. So these are the communications he has directly, my lord, made, my lord, to the office, head office. Lordship kindly sees from and to. My lord, these two columns are important.
You are referring to which page?
So page 30, my lord, 30. My lord,
30.
yes, my lord, the New Delhi office is, my lord, responding, my lord, to him on the basis of his complaint. Lordship kindly comes to, my lord, page 31. Address to whom, lordship kindly sees?
Address to the registrar.
Address, my lord, to the chairperson, my lord.
Page 31.
Page 31. Honorable chairperson, my lord, of the opposition, my lord.
Of the opposition. But this through the registrar.
But my lord, the complaint is against registrar, my lord, addressed to the honorable chairperson.
It is through the registrar, sir.
My lord, let him, my lord, show, my lord,
Let him show, it is written there. What do you mean?
Yes,
This is
sir.
your document.
it is his document, but lordship kindly see, my lord, let him show that he has, my lord, send it to the registrar and, my lord, then, my lord, it went up to, my lord, the honorable chairperson. He directly, my lord, communicated. That is the specific averment, my lord,
All
in
right.
our opposition. Now, lordship kindly sees thereafter also.
Where have you said that this was not sent to the registrar?
I'm coming. My lord, lordship kindly comes to, my lord, page 34.
First, tell us where you have stated.
Lordship may kindly comes to, my lord, page 5, Roman 7. Last 4 lines, lordship.
What is the date at page 31?
14/5/2024, sir.
This is not the direct communication.
14th of May, lordship.
Please read the entire paragraph. You please read for yourself what you have said.
On 14th of May 2024, less than a month after assuming charge and deputation at the Armed Forces Tribunal.
7. You are reading 7.
Yes, my lord, Roman 7, my lord. My lord, the middle portion, my lord, I'm reading. Page 5.
Yes.
That on 14th of May 2024, less than a month after assuming charge on deputation at Armed Forces Tribunal, appellant directly addressed a communication to the Honorable Chairperson of the AFT, bypassing the mandatory channel through the concerned HOD, AFT Regional Bench, Kolkata.
So not written to HOD. You are not saying that it's not written to the registrar.
Lord, lordship kindly sees, my lord, his communication was directly to the Honorable Chairperson.
No, you say not to the HOD. You don't say it was not sent to the registrar. Who is the HOD at the FT? Therefore, we are asking you, please read for yourself before you place it before us.
No, my lord, he directly, my lord, communicated. My lord, my
We don't know what is in your mind. We can go by what is there in the
kindly
pleadings.
comes to page 34.
Yes. Who is the HOD in the office here?
Lordship kindly sees, my lord, it is addressed to AFT Delhi, my lord, directly. It is
Sir,
not registered.
What is this document?
So this is a subsequent letter, my lord, he has given, subsequent complaint. We'll look for
19
these complaints.
19 July.
Yes. Now, Lordship kindly comes to page 35.
19 July is the next page.
Yes. My lord, he is addressing it as through register, but he is not doing it through register. He
No,
is
sir, sir.
sending, my lord, mail
Sir.
to.
All right. So that is
Sir,
your.
sir. Sir, may I interfere, sir?
No, you may not. You please wait. This is not the way.
Now, my lord,
Yes.
page 37 is also, my lord, the same repetition.
Yes. All right. So there may be,
Yes.
maybe, may not be. We don't know. But if what he is saying is, even if he has committed an error, what have you done? Can you repatriate him because of the misconduct, or you are required to take steps? That is his case.
Coming to that.
Yes.
Now, Lordship kindly considers, my lord, so far as, my lord, the deputation is concerned, it is not a, my lord, vested right that, my lord, so far as, my lord, the tenure is concerned, my lord, on deputation, he has to complete the entire tenure. It is not, my lord, my lord, I will place the judgments. My lord, premature repatriation is also, my lord, a fact, my lord, which is happening, my lord, in every cases. Now, my lord, it is not a new, my lord, thing which has happened to him. Now, Lordship kindly comes back, my lord, once, my lord, I'll just request you, Lordship, my lord, kindly comes back, my lord, to the petition, my lord, again. Why, my lord? I'll just place, my lord, certain, my lord, communications before, my lord, the repatriation, my lord, happen. Lordship kindly.
What to place? You want to place it for what purpose? You tell us.
There was a, my lord, kind of, my lord, show cause, my lord, cautioning him that not to do this or not to repeat it again. My lord, in spite of that, my lord, he has, my lord,
So therefore, why do you want to take us through 10 documents? The issue is, you have a definite case. He has done acts of insubordination. He is not maintaining decorum. You are saying that he is violating the rules and the circulars existing in the department. So we have repatriated him. Can you do this? That is the issue. For misconduct, can you repatriate him? That is the only issue. So let us see. He has relied on some judgments. What is your reply? It's an issue of law.
I'll just place, my lord, the order impugn for a moment, and then, my lord, I'll proceed.
Which order impugn?
Lord, the order, my lord, he has challenged, my lord, at page 81.
How many times you will read that?
But the relevant part.
3rd October.
Page 81, my lord, the order of the tribunal.
Or tribunal's order.
25th of March 2025, Lord.
Yes.
I'll just, my lord, place, my lord, the relevant part of it, my lord. I'll not place, my lord, the entire. Lord, the OM, my lord, dated, my lord, 17th of June 2010, my lord, the relevant paragraph has been quoted, my lord, in the order impugn, my lord, at page 91. If your lordship kindly comes, my lord, to paragraph 10 of page 91, that paragraph 9 has been quoted there. It is only saying as and when, my lord, the situation arises, nothing else. So far as, my lord, the submission that, my lord, we have not initiated any disciplinary proceeding, that doesn't, my lord, my humble submission doesn't debar me, my lord, from, my lord, repatriating him.
Sir, may I submit, sir?
So that was one limb of his submission. The other limb is that
Another limb, he has argued
competence of the authority to issue the order.
without approval, my lord.
Yes.
It may kindly comes back, my lord, to page 93.
Yes.
Lord, from however, my lord, may I just read? However, in this case, we find that the respondents have issued a 3 months notice, that is a prerequisite, to the appellant indicating the repatriation with the approval of the competent authority. The interim notice dated so-and-so was served on him along with letter dated 24th of September, which reads thus. Now, my lord, the 3rd of January 2025 letter has been quoted. Lordship kindly sees, my lord, the approval was taken and it was conveyed to him. It is not that, my lord, approval was not taken. Lordship kindly sees, my lord, the middle portion of, my lord, 3rd of January letter. I am directed to convey the approval of the Honorable Raksha Mantri for your premature repatriation from the post of Principal Private Secretary Armed Forces Tribunal to your parent organization, namely Income Tax Tribunal. You are hereby repatriated to your parent organization with effect from 2nd of January. So this is also, my lord, recorded and specific finding. Now, Lordship kindly sees, but thereafter, my lord, the judgments, my lord, which we have relied on. Well, now, my lord, I will place the judgments on.
Sir, I may be given opportunity, sir, for reply arguments.
But Lord, may kindly sees, my lord, it is reported in, my lord, 1990 supplementary SCC page 243.
You have given him the judgments.
But these are already discussed in the order impure.
In the tribunal's order.
You may kindly have a look to, my lord, paragraph 5.
Sir, which judgment, sir?
1990 supplementary SCC.
No. Name of the parties, please kindly say.
P. Soni and others versus State of Gujarat and others.
Okay. Okay.
But here, my lord, the Honorable Supreme Court held, my lord, there is very short judgment. The appellants being on deputation, they could be reverted to their parent cadre at any time, and they do not get any right to be absorbed on the deputation post. We see no infirmity in the judgment of the High Court, and as such, we dismiss the appeal. There shall be no order as to cause.
Any other judgment?
Sir, that is for absorption, sir.
The Lordship may kindly have a look to, my lord, this judgment. Is reported at, my lord, 2000 volume 5 SCC page 362. Kunal Nanda versus Union of India and another. Lordship may kindly have a look to, my lord, paragraph 6. May I just read? On the legal
Just wait, just. Relying on judgments regarding absorption.
just to show
Where is the issue of absorption? Anyway, which other judgment you want?
the two judgments, my lord,
All right.
was discussed in the before the learned tribunal, and learned tribunal, my lord, taking into consideration these judgments, my lord, has passed this order. Now, my lord, my humble submission is, my lord, there is no infirmity in the order because, my lord, premature repatriation, my lord, is possible, my lord, subject to, my lord, 90 days notice is given. Here, my lord, the statutory compliance is there.
Sir, may I submit, sir?
Lord, one more thing, my lord, now, my lord,
Sir, may I submit, sir?
Yes, anything else?
Only one thing, my lord. After this, my lord, subsequent, my lord, development is, my lord, one person is, my lord, already, my lord, working there on deputation basis as, my lord, private secretary. Not she has joined, my lord. Principal private secretary.
Where have you said that?
So this is a subsequent development, my lord. My lord, I can, my lord, bring this, my lord, by way of a supplementary affidavit. My lord.
Who has been posted?
Her name is Srimati Indrani Nath.
When?
It is issued on 20th of August 2025.
On
20th of August 2025, my lord.
20th August. Just one day back.
Sir, when advertisement has been issued, this is the question, sir.
I have a marked copy, my lord, if your lordship kindly allows me, my lord.
Sir, may I submit, sir?
Give us 2 legible copies. You
Sir.
have given him a copy also.
I have got, my lord. I couldn't, my lord.
No, I will show the, sir. I will show the what he has done.
Here and now, my lord, I can scan it and send it to him, my lord.
No, sir. Page number 31, sir. Please see.
Have patience, mister, please. Yes.
No, sir. He is.
Here and now, my lord, I can scan and
That's all. Yes. What do you have to say?
Sir. Page number 31, sir. Of my reply, they have mentioned there is no NOC issued to the candidate who will appear and or appeared for the test by their parent department. Without NOC, how they can recruit the PS, sir? And
No,
also,
that recruitment is not the subject matter here.
yes, sir.
You have not challenged it.
Yes, sir.
Therefore, don't make submissions with reference to that recruitment.
Sir.
If you want to reply to what he has said, you may make a reply. Unless you have set out a challenge to that appointment, you cannot make submissions.
Sir, page number 30, sir, of my reply.
Yes.
Page number 30 of my reply.
When have you filed the reply?
I have filed the reply in the registry, sir. Please take a collect from copy from the learned panel advocate, sir. Sir, in which nothing, sir. As per the available records, any formal complaint against the appellant from any superior officer was not received. There is no complaint against me, sir.
Where is his reply?
Please ask.
Where is his reply? When have you filed the reply?
I have filed the reply 1 month ago, sir, in the registry.
What is the date? They must have given you a filing number or something.
Sir, it is appearing in the online also, sir. Please take a copy from him, panel advocate, sir.
Filed in registry. Yes. It is showing on the website.
Yes, sir. It is appearing on the website, sir.
16th of July.
Sir. In the meanwhile, Sir, in the meanwhile, I want to say, learned government panel council has referred para number 9, premature repatriation, sir.
And I must phone call.
Sir.
Yes.
Have you got reply, sir?
What is it that you want to tell us? Tell us.
Sir, yes, sir. In that, they have furnished information to my RT application, sir. They have stated that there is no complaint against me at page number 30 of my reply, sir.
There is no complaint against you.
Against me. Yes, sir.
Yes.
Yes, sir. And also, whatever applications, representations I have given, they have been forwarded by the registry itself, sir. The forwarding letters have been annexed with the reply, sir. And one more, sir. Learned government advocate has relied on para
You are referring to page 30 of the reply and page 31.
Page 30, sir.
All
Page
right.
30 of my reply.
All
Page
right.
30, page 30 of my reply, sir. Yes, sir. Sir. Now petition, sir. Petition, page number 91. Learned advocate has relied on para number 9. Premature reversion of deputation to parent cadre. In the third line, it has been specifically mentioned, however, as and when a situation arises for premature. What was the situation arises?
All right.
What was the situation arisen? Sir, number of plethora of judgments of the Honorable Supreme Courts and various High Courts, they have said that only on 2 grounds, unsuitability or unsatisfactory performance, only repatriation can be done. Unless they cannot be done. As and when situation arises. Para number, page number 91, sir. Para 10. Unsuitability or unsatisfactory performance. Sir, learned government panel council has relied on Kunal Nanda case. Kunal Nanda case, compilation may kindly see. The Honorable Supreme Court itself has said that Honorable Supreme Court itself has said that at para number 33, this is for absorption. Sir, compilation, you may kindly see, sir, page number 8, compilation.
Your compilation?
Yes, sir.
For what? Which judgment?
Kunal Nanda case.
Yes, we are looking at it.
Yes, sir. The Supreme Court has specifically said this is for absorption.
All right, both judgments. Both judgments. That
yes,
you
sir.
had interjected while he was submitting only. We have heard. Yes.
Yes, sir.
Yes. That's all?
Sufficient, sir.
All right. Heard the parties. CAB. Hold on. No, we have not allowed him to make any submissions on that. You have not served on him, we will not take it on. We can't help it. You should have asked at the very beginning. You did not. Yes, call the next case. Party is appearing in person, you should try to.
Item number 2.
The merits apart, when a party is appearing in person, your conduct should also be such that you don't cast an unnecessary burden on him. Now, when he is arguing and completing, you are saying that we want to file. He is situated somewhere else. There is a way of doing it, sir. He is not bound by that procedure. You are bound by that procedure. He could have done this. You can't do this. You should have filed it. You should have said in the morning, you could have told him that, look, we will not proceed. We want to place this on record. It's not the way. Yes.
Two applications, Millard, 2 and 3. We have challenged, Millard, the order passed by the Central Administrative Tribunal, Lordship, dated 21st of June 2023, Millard. Affidavit of service have been affirmed, Millard. I don't know. You may come back if my Lord wants us to serve once again.
What is the issue? Let us have a look. What is the issue?
It's 2 years, Millard, as far as there was.
Yes, please.
But just a small recapitulation. There was an office memo issued that for the post of draftsman, the scale will be increased.
Draftsman.
Post of draftsman will be increased. It was applicable to all the organization. But as far as our organization is concerned, it has only one post, that is draftsman. It does not subcategorize it into grade 1, grade 2, grade 3. Now, what happened initially when this office memo was circulated, we acted upon it in 1994 and we upgraded. Now, subsequently, there was an audit report. Now, in that audit report, it was circulated that since there is in the recruitment rules, there is no post, the subgradation of the post of draftsman in grade 1, 2, and 3. Such scale cannot be given to them. And on the basis of that, we issued a notice that now we will discontinue that and we would pray for reversal. Now, that particular order was challenged before the tribunal, and the tribunal said that since there is already a office memo which has been complied with for years together, now on the audit report, at a later instance, you cannot come and say that this will not apply. So, my lord, that is the crux of the matter.
How long they have continued on the basis of the office memorandum?
My lord, office memorandum was given, my lord. My lord, that. So, my lord, what I humbly submit, my lord, this is on a small point, my lord, because whatever is there in the order, my lord, it is everything is there, my lord. Now, my lord, since we have not taken any action as on date, and they have also not filed any contempt because we have not contemplated any action that of show cause was issued, the scale has also not been reduced.
So there is no adverse effect on them till
as of now, my lord. But since this order is glaring on us, we need to challenge it, my lord. So, my lord, what I am humbly submitting, I intend, my lord, to hear this matter to be heard out, because if again it goes into the affidavit format, my lord, then it will take some time. The only small point which I have just submitted before your lordship is this, my lord. But, my lord, I have a case. There is one window of salvation as far as I am concerned, my lord. That was a generic order which was not applicable solely to me. And, my lord, in my recruitment, this subcategorization and grading was never there. So, my lord, now that analogy, on the basis of that once, 2 wrongs cannot make 1 right. Now, a particular report was given, office memo was issued on the basis of which we acted. And subsequent, when the audit report came, it categorically stated that you cannot do that. Now, my lord, So under those circumstances, we were bound and we had to do it. So, my lord, just whatever falls from my lord, subject to being corrected in that fashion, my lord, if my lord kindly allows me a day one, next, my lord, I will serve once again and let the other side come, and then, my lord, let the matter be heard out. Because there is nothing too much of pleadings to be made across the bar, my lord.
There are how many respondents?
My lord, two respondents. My lord, there are two WPCT, lordship, which one is 2 and another is 3. In both of them, how many respondents are there? My lord, two in
Same in both the cases.
lordship. Same here.
The same order of the same order of yes, affidavit taken on it. System here is
167, 168. Item number 4.
Lordship is for the petition in this matter. The service is yet not been completed. It's kindly accommodate for us.
We'll hear you, and if there is a requirement of hearing them, we'll issue a notice. If we don't find any merit, then we may proceed in the matter. AFT matter.
Yes.
The writ petition is by Union of India.
Yes.
Yes. What is it? What is wrong with the order?
With regard to the embodied service of the person concerned, is regarding Nakuldar Nayak, who is an ex-Avildar. He is asking for reservist pension in this matter, and against that we have come over here for
Disability pension.
No, reservist pension.
Reservation.
Reservist pension. Reservist pension. We are we are challenging the order dated 27 September 2024.
4th September. Right.
Yes. Let notice be served on the respondent.
Lordship. Yes, sir.
4th September.
Hmm.
Item number 5.
For the petitioners, my lord.
Yes, what is the issue? Tell us.
My lord, issue is, case has very long thing. I was charge sheeted before the retirement date. Then inquiry held. Inquiry found that none of the charges is established. The disciplinary authority disagreed with the inquiry officer, issued the disagreement note, applied. Then they gave penalty of pension cut of 10%. I went to the tribunal in 2011, my lord. I retired in 2008. The tribunal immediately asked that you finalize the date because 3 years after the inquiry, they are not finalizing the case, causing my date. And I was retired without my retirement benefit part was withheld. Then they gave an order rejecting my application and I came to the High Court earlier. High Court
Your
order
punishment order of 2013 has been challenged in
7th
the
of
way
July.
into 2024.
Yes, sir. No, my lord. High Court order is dated 9/9/20.
This is even a second round.
It's the second. This is the second order. After High Court, the tribunal has not applied it. So it's
Where is the first way order?
এটাতে নেই দাম দেখছি
Before this, you have filed only one way. Before this,
and tribunal told that
the tribunal said to give the disagreement note. Then, yes, yes.
consider then it was penalty. I went in 2013. This is the same 13 application. I could evaluate the case to tribunal that we have not applied mine. So please consider this case afresh without considering value.
So after remand, now it has been decided.
Article twice that way they have passed now order as challenge.
According to you, what is the what? No, don't hand us after 515 pages, and now you want to hand us. Show it from the brief. Show it from the brief. You have filed 3 volumes, 515 pages. Page 54. Yes, 454. So the inquiry officer had exonerated you. So what is the procedural infirmity thereafter?
During the, we cannot by suspicion or surmise we can decide. And that decision based on that will perform as the here. Yes, we can make all the outside. Bringing new allegations, this was not on this. So this argument has to be considered out. Then there are number of without getting of that visible. Before that, what is
Serve a copy. Serve a copy. Served. Then what? What instruction? The brief is complete.
Yes, yes.
Have you enclosed all the reply and rejoinder, everything? Huh? You don't know. Is the brief complete? We are asking. Then no, we'll give you time, but don't file anything. Yes, if there is a requirement, because if he's annexed everything, we'll proceed by that. He is getting pension. He is getting pension. So we know, we have seen the order. There is a deduction of 10% only. Yes. The call.
Item number 6.
My lord, I am appealing on behalf of the petitioner, my lord.
Yes.
Yes, my lord. My lord, the matter is regarding to a ACR which was filed by the way of an OA in the March 7th in the AFT Kolkata bench, my lord. But since then, my lord, one of the judicial member has retired and the bench has been quorumless, my lord, and the matter was pending before the AFT Kolkata, my lord. But my lord, as you my lord very well know that my lord, when in the army I am serving as a major, and when an ACR is generated, I was immediately posted out, my lord, and there was an attachment order, my lord. And my lord, when the attachment happened, I was on the attachment for the 6 month, and was subsequent my review CR, which is due on the 7th September, my lord. Now, my lord, I wrote several letters to the AFT Delhi bench for the fulfillment of the quorum, my lord, because one of the judicial member has already retired. So, my lord, on the 1st July 2025, a bench assembled, and my lord, they saw the gravity of my like the matters that we have mentioned in this particular way. And my lord, the matter was admitted, and my lord, we asked for an interim relief, stating that, my lord, because if the review here is again filed, and my lord, let's say the subsequent procedure is that I'll be given a show cause notice and I'll be terminated, my lord. So, my lord, we asked for, because this of this pendency of this particular way, may my lord, that our interim stay may be granted, so that the further proceeding does not happen on the particular ACR, my lord. Now, my lord, this particular on the 1st September 2000 to 1st July 2025, my lord, the matter was admitted, and my lord, as it was asked by the learned counsel for the other side, my lord, a 2 weeks period was given for filing of the filing of the reply regarding my interim relief, my lord. And my lord, since then that particular reply has not been filed, and my lord, the matter was listed for on 4th August 2025, my lord. So, my lord, we again wrote a letter stating that, my lord, the matter maybe against a special bench may be assembled, so that the matter regarding the particular hearing can be taken on the 4th August 2025, my lord. But when that, my lord, that thing did not happen, we filed this writ petition on the August 8, 2025, my lord. And my lord, it is only a matter of conjecture what happened, my lord. Once we filed the writ petition, on 11th, they came out a notice that on 18th, the hearing will be heard, my lord. And my lord, on the same day, my matter was heard for, my matter was placed for hearing in this particular bench, my lord, but it was not, somehow it is coming for hearing on today, my lord. My lord, on 18, my lord, I appeared on that particular hearing, and what happened, my lord, that one of the administrative member who was present in this particular bench in Kolkata, he recused himself from hearing the matter, stating that this particular measure has served under him in the year 2019 to 20. But my lord, my concern is that, my lord, that after that again 3 weeks time was granted, because my lord, when this particular quorum was not assembled, my lord, the order is there with my junior, my lord, over there. So, my lord, again 3 weeks time was granted for filing reply to the interim relief that, my lord, I have shouted and prayed, my lord, and also where, my lord, on the 7th of this September, my lord, my this particular review CR is again due, my lord, and subsequent this proceeding is going to happen. So, my lord, we have only prayed that the interim stay order may be granted. Maybe, my lord, the final adjudication may happen, because right now what has happened, my lord, in this 18th August order, my lord, the learned bench has specifically mentioned that this requires a physical hearing. And, my lord, as of now, it is quorumless in the AFT Kolkata, because, my lord, one of the administrative member has recused, and, my lord, another honorable member appeared from the Lucknow bench only. So, my lord, I am remediless, my lord. So, for that reason also, my lord, I am praying for a subsequent filing of the affidavit, my lord, and also that, my lord, as it has been already prayed, and till date, almost more than 45 days, the department has not filing any reply to the interim relief, and it has been prayed only for 2 weeks period of time. And we were supposed to be granted, my lord, the interim relief, but it was only specifically because, my lord, the other side prayed for like filing of the interim relief, but till date, my lord, almost like for more than 45 days has gone by, my lord, but till no reply has been filed, and another, my lord, 3 weeks time has been given. And, my lord, I don't know, my lord, when this matter will be taken up for physical hearing, my lord, because in another matter in Delhi, my lord, we got an one of the matter orally, my lord, the chairman said that it will take at least in the month of March, my lord, that it will take at least 1 to 1.5 years to to place another judicial member in the Calcutta AFT bench. So, for that reason, my lord, I am remediless, my lord, and we are only praying that an interim stay order may be granted. Otherwise, my lord, I will be put under the reviews here will be there, so I have to file another MA to remove that. And, my lord, even if the reviews here is going to the MS branch, military secretary branch, my lord, I will be given show cause, and, my lord, I may be terminated. And, my lord, only this ACR was generated, my lord, on the series of several counseling letter, because, my lord, I filed a complaint against my CO because a corruption was going on in the mess canteen. And for that reason, my lord, several of this particular counseling letter is there, which I have also challenged on merit, my lord, with the policy of the army orders and other things. So, my lord, those are also under challenge, and my lord, I was put under the ACR without giving any statutory 60 days warning period. Everything is there, my lord, on record. So, my lord, that is the thing, my lord, and that's why, my lord, we are praying that if this particular subsequent event has happened after 8th, and my lord, it's only a conjecture that on the 18th this particular hearing happened only to sabotage this particular High Court hearing, my lord. Because on 11th they only came out with the notice stating once they got this particular reply that on the 18th the bench will be heard. And once the bench happened, my bench assembled, my lord, one of the honorable judges recused himself from hearing the matter. And my lord, we don't know that when this matter will be.
You are
heard.
repeating the same thing again and again and again. Yes.
Sorry.
Yes.
Scope for interim order. My learned friend is serving the army. He is not in shape 1, as a result of which page 95 a notice was issued to him wherein he had to be within a stipulated time.
So what is his audio quality is very, very, very bad. We are unable to. All we can understand is that he's saying the same thing again and again.
FT at present is not functioning every day. The bench is presiding on different days.
This much we could gather that as per his request, they have assembled twice or thrice. Yes.
They assembled, but one of the benches had, because he had served under it, he had released the matter, and again.
And why are you not filing a reply there?
I could not be filed because his posting was in from Assam. So from there, all the records and pleadings has to come as a
45 days. This is a July order is before us.
1 week will be filing before the AFT, our affidavit. This matter wherein he had to be shape 1, because of not being shape 1, he has been issued notice. The page number 95 is the order against which.
We are not going to go into the merits of the matter directly. It is to be decided by the tribunal. Yes, but he is saying the quorum is not there. What?
With regard to the quorum, we do not stand against him asking for a transfer petition to principal bench. Principal bench, there are several of these matters which have been already transferred to a principal bench. We are giving our consent that it may be transferred to principal bench and he can proceed there.
Then if your other matters are transferred, why don't you get this matter also transferred?
No matter has been transferred, my lord. That is wrong information.
Please unmute yourself.
A stay against the disciplinary proceedings in OA 14. There is no pleading with regard to the same or annexure annexed to the.
My lord, am I audible? My lord, no TA, I have not transferred any matter, my lord. And my lord, even if I start a transfer proceeding, my lord, it will take more than 6 months. Even for the matter to go over there, and by that time my interim leave.
How do you say you are remediless as per your requirement? The tribunal is being convened, bench is being convened, and you are saying you are remediless.
My lord, the next hearing has.
Then you also read some kind of a conspiracy into it.
No, my lord. The next hearing has been given on the 26th September, my lord. But that time my interim relief will be exhausted, my lord.
How do you know?
My lord, because it is saying that they have mentioned in the order, my lord, that it requires a physical hearing of the particular matter. And my lord, as long.
Meantime, it will become infructuous. How do you know?
Because my lord, my review CR is due, my lord. By the time my review CR will be generated, my lord, and my particular review CR will go to the MS branch, my lord, and the subsequent procedure will go on, my lord.
First, under when somebody is not within shape 1.
So he is under some low medical category, and therefore he has been issued a show cause.
Yes.
This much we have understood.
Wait and again go for a further medical examination.
Yes.
This is a disciplinary force.
Yeah.
Wherein everybody is required to be in shape 1. Otherwise, we.
So what will happen? We want to know what will happen on 7th if he is.
A review would be taken regarding his physical assessment.
Then.
Which is required to do.
No, he says on 7th there is some action is going to be precipitated against.
If he is not within that period in shape 1 again, then show cause notice. He has to face that.
How can we stop that? Why should we stop that?
My lord, pardon, my lord. My lord, I did not.
Why should we stop them from having your physical assessment done?
No, my lord, this is not regarding the physical assessment, my lord. This is regarding the ACR, my lord. This is not the. This is regarding, my lord.
On 7th there is a review. to be
reviews
conducted.
here regarding my performance, my lord, but that is regarding to this ACR, because my lord, if the ACR is quashed, then the reviews here also I have to file another MA to
Where is the ACR impugned?
ACR has been filed, my lord, in the month of my lord, it is in the month of December, my lord, 2024.
Page number?
My lord, that is 1 second, my lord. It is in the page number 28 of my writ petition, my lord.
28.
Yes, my lord, 28. It was yes, my lord. And this is pen and my lord, this is a typed copy because
December
it is a
24.
Yes, my lord. From then, I filed my this particular way in the March of 7th March 2025, my lord. And from that moment, my lord, it is pending. My lord, we are only praying, let the adjudication be done, my lord. But if the interim order
Who
is
is
not granted,
stopping the who is stopping the adjudication? That is what we are unable to appreciate. You are
My lord,
yourself saying that when you have raised an urgency, they have convened the tribunal. Now, on
No,
the
no, my-
last day, one person had to recuse because you have served under him. So, what is so abnormal or?
My lord, the matter is registered on 26 September, my lord. My only contention is that,
So,
my
you
lord.
have come to the High Court for preponing the matter.
No, my lord, we are asking for a stay
The
order in
urgency, you move them
subsequent.
for you move an application for fixing an early date.
No, my lord, my review CR is on the 7th, and if it is
This was
submitted,
known to you when the date was given on 18th, or you did not know of this fact.
My lord, pardon, my lord.
When the date was given on 18th, you knew that 7th there would be a review ACR or
My lord, we
CR.
mentioned it, my lord, but still the date
We
was
don't
given on
know.
the.
How do we know what application you have filed?
My lord, it is, my lord, we mentioned it, my lord, because that
We
we are
don't
asking.
know. We don't know. That is much after filing of the writ petition.
Because, my lord, we filed the way in the March of
We don't
March.
know. Sir, please, your oral saying will not suffice.
That's why, my
We
lord, we are
don't know.
praying.
The order was passed in your presence. If there was an urgency, you were required to ask the tribunal that please keep it before 7th. If they have not, if you could have filed an application before
That's
the
why, my
tribunal.
lord, that's why, my lord, if it is mentioned, it speaks for the 26th September, we are summarily saying, my lord, that my interim relief has not been granted by the tribunal, my lord, because my 7th, if that particular review CR goes on
Interim relief,
record,
what
my lord.
interim relief? This cause of action arose in December 24. What
No,
interim relief
my
to
lord,
be
I
granted
have
in
to
August?
I have to file the statutory complaint, my
After
lord.
9 months, you want us to grant an interim order?
My lord, I
That
filed a
also when
statutory
nothing has been done in the tribunal. Where is the application you have filed after 1st July 2025?
my lord.
After 1st July 25, have you filed any application for any interim relief?
My lord, it was in the way only. The March way only it is there, my
Therefore,
lord.
we are asking you, it was admitted on 1st July.
Yes, my lord.
So after that, it has been fixed for you at least on 2 dates.
Yes,
When
my
did
lord.
you seek an application, file an application for interim relief that you
My
have
lord,
rushed to the High
part
Court
of the
here?
way only, my lord, and it is in the first, my lord, the 27th order only. It is said that they are supposed to file a reply only, my lord, in this regard. Only the 2 weeks time was granted, and my only by the passage of time, my lord, my relief is not being granted, my lord.
To go before the tribunal, we are not going to interfere in the matter directly. Why you have filed? We are still very sorry to say, we don't know what is the urgency. A cause
My
of
lord,
action arose in December 24. As per your request, dates have been fixed. Last day had to be adjourned because the member recused. Now you are saying there is an urgency. And this urgency you say has arisen after filing of the writ petition.
my
Those
lord,
facts are also
we have
not
sent
before
some
the
letters to the AFT stating that my review CR is due, my lord. That is there.
Huh?
My lord, we have written letter to the AFT principal bench stating that my review CR is due, my lord. For that reason, the urgent bench may be assembled, my
A
lord.
letter is to be written.
My lord, I don't have any other, like as per the statutory remedy, I don't have any option because, my lord, I have already filed in my way the interim relief. And my lord, since it has been there and as almost like a 6 month was passing by, because in the March I have filed and before that I have to go by the statutory.
Those facts are not before us.
My
Those
lord, it is
facts
there.
are not before us.
My
Where
lord,
is
we are
the
also
review ACR
filing
date
a
fixed?
supplementary affidavit, my lord.
Huh?
That's right, because of the subsequent event that has happened between
Yes.
the 8th August and 18th August. I
Yes.
also prayed for, my lord, at the beginning filing of a supplementary
We
affidavit.
don't
my
know.
lord.
We didn't hear you. We said that when it is called, you say whatever you want to say.
Yes, my lord, we are praying for filing a supplementary affidavit, my lord. That is also there. I at the beginning, my lord, at the mentioning time, I mentioned, my lord, that
We have not heard your mentioning, sir. We told you at that moment itself that because it is at item 6, you let it be called. We did not hear your mention.
yes, madam.
What supplementary you will file?
My lord, this subsequent event has happened after the 8th August to the 18th August, my lord. Because, my lord, I am remedialist, my lord. Because my lord, on the 7th, my review CR is due, my lord.
You are not remediless. You are expecting something to happen against you. And in view of such a presumption, you are rushing to the court. The remedy is very much there. You have yourself said that the tribunal has convened to hear your matter. So don't say
Yes,
you
my
are
lord.
remediless.
But my lord, right now, it is in the
Rejection
order.
of interim relief does not make anyone remediless. That means your remedy has been
My lord, I
exhausted.
will be terminated because this review CR when it
As
is due.
state, matter is adjourned for filing a supplementary affidavit. How much time you want?
My lord, within 7 days period of time, my lord, the matter may be assigned. Before 7 September, my lord. Before 7 September, my lord. Any time before 7 September, my lord.
After 1 week. 1 week.
Item number 7.
My Lordship, Mr. Ali Leonard, Senior Advocate, is appearing for the petitioner, my Lordship, petitioners. My Lordship, today, due to some personal difficulty, he could not come, my Lordship, today and tomorrow, my Lordship. I'm praying for adjournment.
Received the brief just a while back, my Lord. I just to keep it the next week, my Lord, so that I can get the instruction.
Asraf.
Appearing for the first time, my Lordship.
For the petitioner.
Item number 8.
Yes, Your Lordship, I am for the petitioner. Lordship, kindly give 3 weeks time because service is not complete.
Not required. Don't worry about service. Please proceed.
Your Lordship, actually, due to some problem in the post office, a total server and software is uploaded, and that's why IPO registration is not doing properly.
We are not asking for service. Let us see what is the issue. If required, we'll direct for serving notice. Address us on the merits. Yes, what is it?
Your Lordship, senior counsel is not present today, and that's why I'm praying not today.
Same order, 3 weeks.
Item number 9.
In this matter, my lord, I am for the petitioner, my lord. This matter also, my lord, the service has not been completed. Am I audible, my lord?
Yes, why a service is required? Let us see whether we.
My lord, this,
any-
if your lordship takes up, my lord, this matter, what happened, my lord? If your lordship, my lord, takes up my application at page, my lord, page 11, my lord, kindly straightway come to, my lord, paragraph 4C, my lord. The respondent herein, my lord, they are the transferee posted, my lord, Ranchi zone. And the circular was issued in 2011 by the government, my lord, saying, my lord, the person who will be transferred or opt for transfer, my lord, they will be below the, my lord, the seniority list of the direct recruitee, my lord.
Yes.
Circular, your lordship, find, my lord, at 4C, my lord, paragraph 4C, kindly sees, my lord. I have quoted there. That question, my lord, has not been dealt with by the tribunal, my lord. My lord, kindly come to paragraph 4C, my lord. The circular I have quoted there. Fourth C, my lord, II.
So he will be junior to those who have joined after him also.
Yes, because, my lord, he of the transfer, he was posted at, my lord, Ranchi, and he transferred to Kolkata zone. Now, my lord, the issue was there, my lord, that initially it was banned that they cannot transfer from Ranchi to Kolkata. Ban was lifted, and on the condition that he will be of this, but he will go down to the person who has appointed even after their appointment, my lord. And my
Where
lord,
where is that provision?
my lord, kindly 4C II kindly sees, my lord. Paragraph 4C II of the my petition, my lord.
CII.
II, my lord.
Of
Of my petition, my lord. Of my writ petition. May I place, my lord, or
No, we are asking you where is the provision. We are not asking you where have you stated.
then, my lord, circular, my junior will, my lord, place the circular dated, my lord,
Because
27.
for you have written the transferee will be placed below all officers
My lord.
appointed regularly to that post grade on the date of his or her appointment on transfer basis.
My lord.
We are asking you whether those who join later also they will prevail over you will have they will have to.
No, my lord, if suppose, my lord, the person was appointed after the respondent transferred to Kolkata zone, then, my lord,
Yes.
the respondent will be above that persons. But, my lord, here what happened, my lord, suppose, my lord, that they
No,
appointed.
here from what we gathered from the tribunal's order is that he has been given he has not been placed below those who have joined after him. How can he be placed below those who have joined after him?
No, my lord, what
It is
happened?
on the date he goes, he will go at the lowest. That is the only thing it says.
Lordship. Now, my lord, question is that what happened here? Though he has been transferred subsequently, my lord, during, my lord, he was in Ranchi zone, the other incumbent, my lord, they have been in direct recruitee is there. Then, my lord, they are automatically, my lord, by the provision of the, my lord, promotion, my lord, they have been above the, my lord, the persons who come from, my lord, Ranchi. That was the circular.
Sir, the applicant joined in the commissionerate in 2016. The respondents joined in the commissionerate by way of direct recruitment in 2018, 2 years after him. Now, how he can be placed below those persons who have joined 2 years after him?
My
My
lord,
lord, page 100, this circular is page 100, my lord.
Does it say that even those who join later, they will be senior to him just because he has gone there on a request? That he will for all times to come, he will remain as the junior most person in the transferred place.
Page 100, my lord, paragraph 2, my lord. Paragraph 2,
on
my
the
lord.
date of his or her appointment on transfer, correct? We are asking after that how it can be applied, how he can be made.
After that it will not be applicable, my lord.
But he has been given seniority with those who have joined in 2018. He joined in 2016. So how this will apply?
No, my lord, what happened here, my lord? Then NR Parma case, if you lord realize, my lord, it was, my lord, when the vacancy was, my lord, there, it was sought for, my lord, to the my lord, concerned authority for recruiting authority, my lord. The date when it was sent to them, my lord, that will be the date of their seniority. My lord, in 2000, my lord, there your lordship find, my lord, the person who have been promoted above the, my lord, the respondent, there, my lord, the vacancy was there, my lord, long before they transferred to the Kolkata zone, my lord. Therefore, the date when the vacancy was, my lord, left open and recruiting authority was asked for, my lord, taking all process for their, my lord, promotion, then, my lord, at that point of time, the person, this respondent was not there. Well, the date mentioned there, my lord, in the notice, my lord, for filling up the vacancies, that was the date of the seniority, my lord. That from that it will be counted, my lord, in our Parma's case, my lord.
We don't, whether such a case is there before the tribunal. Also, those requisitions were sent in 2016 and 17.
My lord, requisition
2015 and 16, my lord.
15, 16.
15 and 16.
No, 15, 16 and 16, 17, both. You come to page 4, paragraph 4 of the tribunal's order.
But it was requisition sent for the recruitment year 2015-16 and 16-17 was 3rd November 2015 and 23rd September 2016.
And when has the applicant joined?
The applicant joined 5th September 2016. Then 6th February 2017.
So these are persons who have been newly appointed.
Well, they are the applicant before the tribunal. They challenge that circular. They're saying that no, you will have to place me. One thing more, they are the promotees, my lord. And two
The
questions.
the respondents before the tribunal, they have been directly recruited.
No, they are promotees. They have been transferring from my lord, Ranchi and other zone to Calcutta.
No, sir, they are the applicants.
They are the applicants there, my lord.
We are asking about the respondents there. He is claiming seniority over one respondent number 6.
Yes, yes, my lord. That is my junior will, my lord, help you, lordsman.
1 minute.
এখানে লাগানো আছে কোথায় একটা এই তো স্যার আচ্ছা আচ্ছা
Very well, you serve notice.
My lord, may I come back on, my lord, Tuesday next, my lord, next Tuesday, my lord?
Let notice be served on the respondent. Intermission means nothing.
As a lordship.
My lord, grateful, my lord.
Item number 10.
Time for the petition. I have filed this writ petition challenging the order dated 17/12/2024, passed by the Learned Central Administrative Tribunal, Kolkata Bench. My lord,
This game is recognized.
Game is not recognized at the time when he was given an appointment. At the time of 2020, his ball badminton was not recognized. My lord, kindly come to page 42 of my writ petition.
You are saying the association's recognition had lapsed.
Yes.
We are asking you whether the game is recognized.
From 2019 to 2020, it was been recognized, but 2020 to 2021, it was not recognized. The Ball Badminton Federation also admitted, and there is a letter from the Youth Affairs to the railway authorities stating that it was not recognized in the year 2020. Kindly come to page number 42 of my writ petition.
Is 41.
42. The 10th and the 12th was educational. He was given firstly a provisional application on this subject to his verification of his post achievement and everything. Now, page 42, his certificate which he has submitted happens to be a fake. The department's deputy secretary to the government of India, Ministry of Youth Affairs and Sports Department of Sports, New Delhi, by a letter dated 14/2/2020 has stated that Ball Badminton Federation of India has not got recognition of ministry in the year 2020. And his appointment was in the year 2022 to 2021. So the financial year of 2020 and 2021 will be for the writ petition, for the respondent number 1.
Serve notice.
There is a contempt application.
There should be. The order is of last year. Why you have come after 1 year?
There is a contempt.
To comply subject to result. What can be done? So December 24. Where were you?
It's a departmental process.
What departmental process? 9 months. You are waiting for the contempt. Then you file the writ petition.
19th is a contempt.
First issue notice. Let's see.
Next date is on 28th.
We don't know.
Kindly state till 28th.
No, sorry.
My lord, the petitioner responded number 1.
What is the day? What is the order passed? Show us in the contempt proceeding.
The order is not passed, but order.
Then if something happens, we'll see.
My lord, I'm sure.
Yes, we are not going to pass any.
There is a summon copy and the order has not been.
So was the last order.
My order is on 19th August. The matter was.
So was the last order.
The order is not uploaded. I'm saying the supplementary summon copy and the.
What is that?
And the server copy that the matter
Unless
is
you
released on
give.
20. My lord, I don't. The order has not been uploaded in the server till now.
Then what is the? Where is the
My
apprehension?
lord, next date is on 28th.
There may be a next date. So what? What is happening on the next date? Tell us.
My lord, the petitioner.
What is happening on the next date? Tell us.
The next date is for the appearance of the contempt.
Where is that? Show us.
My lord, summon copy and the.
The direction was to be done in 3 months and you file a writ petition after 9 months. And you want a stay. Go and comply subject to result.
Malad, it is Andhra Pradesh. I have to serve.
We
it to
don't know
Andhra
where it
Pradesh.
is. That is hardly the concern. Today, saying this, making these issues of distance
And
is
state 28.
sorry. Let us see. Appear through advocate. You let them appear. What is the big deal? He has not been asked to personally appear. If there is something, then you tell us. If something happens, you may file an application. We are not stopping. Issue notice by speed post. List after 2 weeks. I think we are issuing notice.
But if it is not there, then we will not. It will not.
All right. Learned advocate has made submissions.
And for the petitioner, my lord, laid by Mr. Sudipta Dashgupta, he is engaged in court number 11, my lord. Kindly make it not to.
I represent the state in this matter. For interfering on my full submission.
My lord has my lord, impugn order, my lord, in short, my lord, my case is I was
Yes.
The point that is involved here, my lord, is that in 1997, my lord, I was appointed on compassionate ground in the post of Group D lab assistant, my lord. My contention is at that point of time, I had the qualification and there were vacancies in Group C and other candidates were appointed in Group C on compassionate ground. Subsequently, my lord, persons who were not appointed at that point of time, my lord, in Group C were upgraded to the post of Group C in on that basis that they were eligible. My lord, I filed this first way application I filed, my lord. Thereafter, it was sent before the authorities for consideration. My lord, if your lordship kindly comes to page 49 of the application of this application, my lord, page 49, my lord. If I place the my lord,
No, the first round of litigation before the tribunal, you were saying others have been promoted. I have not been promoted.
yes, my lord, it was relegated.
Yes.
For a recent decision, my lord.
Yes.
If your lordship kindly comes to my lord, page.
And what is the basic qualification for appointment to Group C?
Well, Group C, one has to be higher secondary and higher secondary pass minimum.
Group C
Yes, ma'am.
or Group D?
Group C, higher secondary.
Where is
Group
that?
D, class 8 pass, my lord, subject.
And Group C is higher secondary?
Minimum higher secondary.
What is the qualification for Group C?
Higher secondary, as I understand.
For Group C?
Or division, your division path, LDC it is called normally.
Higher secondary pass is appointed as lower division clerk.
Compared with instruction or specific.
Anyway, whatever it is, that was given to you in 97.
In 97,
Yes.
subsequently, my lord, in the rescind order, I am placing only one paragraph of the rescind order, which was under challenge in the way application, my lord, page 49, last paragraph. There is no such right for providing him out of turn promotion, since the facts and the circumstances under which Gautam De and 8 others, as per list supplied by the petitioner, were allegedly given appointment in Group C post, are not known.
Correct.
My lord, this was my specific allegations that these persons have been given or similarly circumstance as me, and these persons has been given upgraded to LDC since they were eligible. I applied for parity. They say that whether it's not known to the department and not been decided.
Even if it is known after 2 decades.
Well, they were promoted not of into 1997, my lord.
Yes.
These persons were upgraded in the 2019 or 2020.
Where is that statement show us?
My lord, it is at page 49, my lord.
No, where have you stated in your representation that they have been promoted just now and I have been bypassed, though they were inferior to me?
My lord, I have not said that they are inferior.
That's not your case, therefore.
Inferior? No, ma'am.
Unless they are inferior, how they may be promoted?
We are stand on the same footing.
Where is that? Let us see in your representation where you have said that.
It is my case that has been
Show us where it is said, sir.
My lord, page 46, my lord, if your lordship can.
Yes.
And my lord, page 47, I have given the names, my lord. This, my lord, the department is saying that this is not.
Forget about department. We want to see your case.
My lord, this is, I have given the list and the representation.
You have not said anything. You have not said, just given a table.
Yes, table that these persons have been upgraded.
Joined as LDC in different government departments, not elevated.
Yes, joined.
You are submitting something else and the document says something else. They were not elevated. You please read page 47.
Well, joined as LDC.
So in 97 you were joining, you had joined. Therefore we asked you, it's not a question. We don't know what your claim is. Whether you're claiming promotion, whether you're claiming parity at the time of joining.
I claim that in 97 I should have been ought to
So
have-
therefore, so after more than 2 decades, you have awoken to find out that they were given a better post and you were not.
But I was giving
So
representation.
97 you joined and you filed the
No, no,
representation in 22.
No, before that, my lord, the college authority also.
In 2017, there is a recommendation. 20 years after your joining. We have seen. That's all. Heard learned advocate for the petition.
Otherwise entitled to.
Yes. We make it clear.
C, D has gone down, possibly.
Yes,
In the
promoted to
operative
group
parts,
C, it should
it
be.
group C.
You
but
know,
it's
probably it has
Promoted to group C. Just देख लो D तो नहीं लिखा है. Kept on record.
And 12.
May it please, my lords, I'm appearing virtually, my lord, in this matter on behalf of the petitioner, my lords. My lord, this is the third round of litigation, which is before your lordships. My junior is there, will file the affidavit of service, my lords.
Which is the impugned order?
My lord, may comes to the second page after page 73.
No, give us the date of the order.
22nd of April 2025. My lord, the order impugned that has been placed before your lordship. If your lordship comes to the second last paragraph, it says Mr. K. Jha, learned counsel, wishes to file rejoinder to the reply filed earlier by the state respondents. This observation by the court is entirely contrary, my lord, in view of the fact that I had asked the learned tribunal to pass the order because entire hearing of the matter had taken place and there was nothing to put on record because all things are already on record. This is the third round of litigation. So instead of passing in judgment, my lord, the court asks me to once again file a rejoinder thereto.
So what is the forum for curing this error in the order, error of record in the order?
My lord, this I could have approached the tribunal, but that would have been.
You could have, or that is the remedy only available to you. How can we do this?
But this is the petitioner, she is suffering since 2009.
We don't know. We will go by the order as it is. It stands without objection till date.
Then your lordships, I'll beg your lordships to pass a direction directing the honorable tribunal to prepone the matter and expeditiously dispose it of.
Why have you not approached the tribunal? We don't want to encourage such practice.
I do not want to make that statement which came from the tribunal, but I am bound to do so. The reason being, the tribunal is functioning with a single judge who is not a judicial member. And categorically, it was said by the tribunal that this adjudication requires a division bench, and by the time that the date I am giving, the division bench will come. This was what was said in the court, my lord. What will I do? I am in a very precarious situation. Kindly understands the predicament of the petitioner who is fighting since 2009.
Or?
I beg your pardon, my lords.
Fighting for what? What is the benefit claimed?
My lord, the petitioner, she is a GNM. And in 2012, a notification came that from the GNM, who have 3 years training, they can be promoted to the post of, or rather, then apply for the post of the staff nurse, grade 2. We made our application, pursuant to which a fresh notification comes up without considering the application of the applicant, and thereafter a new recruitment process is being initiated. This is my claim.
Now it is fixed for hearing on 13th November.
13th November, your lordship. And by that time, whether the division bench will be there again or not, the judicial member.
The bench is not required for this matter.
This is what was said by the court there, my lord.
We don't know those. See, you whatever you are saying on instruction.
My lord, I had appeared there. I had appeared in the tribunal in this matter, my lords. I leave it to your lordships in such situation, your lordships.
But have you filed anything after this order, or you don't wish to file?
I don't wish to file because everything is on record, my lords.
How can we fix a date? We don't know the board of the tribunal. It would not be proper to do that. But we understand that you are also waiting since the last about 2 years.
My lord, we started this litigation with 30 odd applicants. 2 are just still pursuing their rights. Rest have gone.
Why don't you make an application for preponing before the tribunal or for early hearing?
What fell from the court there, my lord, was in absence of a judicial member, this cannot be decided. Though it is not on record. I understand that, my lords.
No, we appreciate what you are saying, but that the legal position is different. It is very much, it can be considered by the single judge. So
then your lordships may grant me liberty to approach the tribunal, and if in the event I approach, that will be considered, my lord.
That is the best that can be done.
My lords, my lord. I leave it to your lordships. Because this will catch
the learned advocate for the No, he is saying all have aborted now. Only 2 remain on the record. There may be, but he is saying now only 2 persons remain. The others have abandoned the litigation.
My lord. Item number 14 is also the same matter, my lord.
Huh?
Item number 14 is also the similar matter, my lord. Those 2 applicants, one is 12, another is 14.
Order of same date.
Order of same date, my lord.
Please be sure, otherwise, you know.
I'm sure. I had appeared, my lord, in the matter.
Huh?
It's the same date order.
Is the next case?
14, my lords.
You are appearing in both. Give us the file. Give us the file. In between, there is another matter.
13, because two matters, 173 and 175 is there. 174 is in between, my lord.
Thank 22 for same order.
Same order, my lord, same order.
And in both cases, there is only one petitioner.
One petitioner, my lord.
Original side, listed matter, underwriting new application, serial number 1, Sudip Toshil.
Item number 1, my lord. This is specially assigned matter. What is it? Can you please give us a brief background?
But I appear for the High Court administration. The second matter is.
You are the appellant in both cases.
The second matter, my lord, I am the appellant.
And in the first, the writ petitioners.
The person, lord, who succeeded in getting the employment, the learned judge by an interim order directed the High Court administration not to fill up that one post.
Oh.
Despite receipt of an appointment letter, he couldn't join. Order intervened between the appointment letter and his joining. So the first appeal is at his instance. The successful candidate at his instance. The writ petitioner is an unsuccessful candidate. I'll make my submissions on that.
May I indicate, my lord, there is no stay application in the first place, my lord. The appeal is yet to be admitted. There is a condonation, there is a delay of 188 days, for which purpose I have taken out the GA, which has been duly served upon both the respondents.
188 days.
188 days, my lord. My lord, until unless there is the appeal is admitted, I am not supposed to.
Any orders have been passed earlier?
No, my lord, not so far, my lord. But if your lordship so direct.
No.
But that is standard, not fixed, not the matter for final hearing. But before the date, then it went to, I think, another bench which was released from us.
Oh, yes, it has been released. In the other case, it is the same situation.
There is no delay in the other case. That appeal has been.
Otherwise, they have been coming up together.
Coming up. I could be considered because this appeal was not there when Justice Harish Tandon took up the this appeal came late.
And hence there is a delay of 188 days.
In the second case.
In the first one, my lord, in the list, which is APOT 124 or
124.
2025, my lord.
Similar application and
My lord, the reasoning which is attributed for the purpose of delay has been explained in paragraph, my lord, 7 onwards in GA, in connection with GA1, my lord. Your lordship, they allowed me to place, my lord.
You preferred a review also?
No, my lord. There is no review application. My lord, there is a writ petition which has been taken out at the instance of the writ petitioner.
Just read para 7.
My lord, that is a typographical mistake, my lord. That should have been the.
So you have not filed any.
It has to be read as an appellant, my lord, instead of review application.
Cut and paste. It's a cut and paste error. Yes. Yes, take down. He's saying there is no stay.
Application, my lord, in the first place.
He says there is no stay.
My lord, there is no scope of stay because he's the one who is entering the.
Huh?
I'm pursuing the appeal, my lord.
But the employer is not in appeal.
Obviously, if at all stay, they would be requiring stay. Why he would require a stay? That's why we are wondering. So, in terms of the interim order, oh, he has to do nothing. It's only for them.
My lord, the only thing is.
No, we otherwise just what we just want to have a look at what it is and whether the otherwise it is ready. Affidavits are not required to be filed now.
But what happened was that this interim order was passed, giving directions for filing affidavit and providing letter charge. But this we are against that interim order. But on the face of the interim order, I would say that this direction could not have been given going beyond the prayers in the regulation. And in law, a general candidate who has applied as a general candidate cannot ask for reservation or preservation of a post of a reserve. This is not the short point in the appeal.
So this appeal only arises out of the interim order.
And restricted to the directions contained in the interim order that one post of the reserve candidate should be kept vacant.
Reserve category should be kept vacant. For the petitioner who is a unreserved category.
Your lordships will find.
Yes.
September, this order was passed. There was a hearing on the 25th of September also. If your lordships kindly come to page 100 of the state petition.
In the first case.
In this writ petition, it was first taken up.
No, in the first appeal, APOT, second one.
Second.
Just now he said no stay has been filed in the.
No, sir. In the second one, the High Court administration has filed a stay. I have served not filed copies.
So that is a different way, not 124. That's not APOT 124.
That is 113, my lord.
That's why we're asking. Yes. All right. Yes.
But to come to page 100. But the point was taken at page 101. Kindly come to the bottom of this page. On behalf of the respondent numbers 2, 3, and 4, it is submitted that the as much as the petitioner who has admittedly applied under the unreserved category is seeking a writ of mandamus directing respondent number 2, 3, and 4 to appoint the petitioner as a candidate under OBC for which he never applied. This point was taken.
Order. The controversy is that the advertisement, it was indicated that OBC B EC, that is exempted category, posts are available. But not under the High Court rules, if there is no suitable candidate, then we can consider OBC B candidate. There were 20 OBC B candidates who had applied. He applied, he is an OBC B candidate, but he applied as an unreserved candidate. He applied as an unreserved candidate. And so he took the examination as an unreserved candidate. Then not much later, when this selection was finalized, then he came and filed the writ. This is not the short point. But if my learned friend is in difficulty today, I really don't mind coming back to next week. There is no difficulty.
My lord, in that event, my lord, I have some objections in that regard because I'll explain, my lord, what has happened. They have, my lord, I'm not opposing Mr. Kaur's difficulty. Well, sir, but
No, he is not saying, he is not
my
claiming
lord, the
any
difficulty,
difficulty.
my lord, the situation right now.
You are for the respondent before the
I'm
report.
the person who has suffered this order, my lord. My appointment has been kept in abeyance since September 2024. Now, my lord, what has actually happened?
So you were respondent in the writ petition.
I am respondent. I am the private respondent in the writ petition. Now, my lord, they have made out a case.
What has the order said about you?
My lord, because I am the successful candidate, I
Yes.
have been favored with an appointment letter.
Yes.
Now, because of the writ petition, what happened, my lord, writ petition being a
So what? How are you affected by
by
the order?
appointment, I could not join the post, my lord, despite having an appointment letter.
The order on the
6th, my lord.
the third page says it is clarified that notwithstanding the pendency of the requisition of the that could be appointed to all selected candidates except filling up the vacancy under OBC B category. There is only one post. This is how the High Court administration is also acting.
Why such an order has been passed? Just tell us what. We are not concerned about right and wrong. What has the Honorable Single Judge?
That's fair. As unreserved category, but admittedly
He was OBCB.
OBCB.
Yes.
And he said that in the advertisement, it was not indicated that in case we do not get OBC BEC,
Oh, it will be made available to B.
that's the
So therefore, he said, because of this ambiguity in the advertisement, I am missing my chance. Therefore, the court said that let this one vacancy stay.
But the law is that if you have applied as an unreserved candidate, you cannot switch over after the selections are over. This is not the consistent law. And Lord, this interim order, Lord, really interferes, Lord, so far as the administration is concerned, in Lord filling up the post. Lord, this is a post of recruitment to the post of assistant registrar court record, which is a very, very important post. I am ready to go on with the appeal.
What is the job profile of ARCR?
Registrar court record.
Well, they are the one who used to take dictation directly.
Yeah.
I thought so. Brother was saying something else. So if he wants it on the next week, we'll consider on the next week.
But that's what I said.
Your whole ground is that perhaps it was not stated in the advertisement, and therefore, based on that, I have made the application. You are more than welcome.
My lord, in the meantime, my lord, if I may allow to express my difficulty.
We have understood your definition.
No, my lord, there's something which has been missing out, what Mr. Kora has submitted with the deepest of
No, there's
respect.
nothing missing. We just wanted to
case
know
has
the
been made
premise
up.
in which the order has been passed. Whether the order is sustainable or not, we'll see.
That's where I'm joining issues, my lord.
Which we did not ask him. We only wanted to know why such an order has been passed. So now we know.
My lord, in 2017, this vacancy which has been created in 2021, this has been carried since 2017. Now the 2017, the same.
We are not on the merits yet.
Because
Just wait.
another writ petition taking advantage of this particular interim order, another writ petition has been preferred by the same writ petitioner, which is as numbered as WPO 13 of 2020.
A second writ petition.
A second writ petition whereby he is asking for appointment in terms of the employment notice in 2017, because he ought, if this particular decision would have culminated at that point in time, he would have been getting the opportunity of the job at that point in time. Now that is
That's not before us. Yes.
Your lordship kindly turns to page 51, strikes why I was constrained to file the writ petition to the court. The advertisement, the employment notice by the High Court on 17th of September 2021. That your lordship will say, see the classification of vacancies.
This is the advertisement pursuant to which the process was set in motion.
Yes. Your lordship can see OBC A, then OBC A EC, then OBC B EC.
Yes.
Exempted category. There is no OBC B.
Now, what is this exempted category? Can you please tell us? Tell me. I'm from speaking for myself. I'm not aware of this. Yes.
That exempted category candidates are taken from the National Employment Exchange, whose names are registered in National Employment Exchange and takes. But kindly correct me if I'm wrong. Who takes part in the census jobs?
Acha, those census retrenched employees.
My lord,
perhaps.
If I may correct, my lord, these are the persons who have given their land at some point in time to land users also. They have given a land to the government at some point in time. In exchange of that, they have been awarded with favored with a certificate, which says at a point in time, if there is any employment, then they can apply under that exempted category.
There is a provision here.
This is not declares not which are the reserve category, and under OBCB there are certain further classifications, and these candidates, they are given exempted category because of certain preference that they have given to the state in lieu of their land. That's why not OBCB, they belong to OBCB, but they are given this exempted category.
So they prevail over the OBCB in the matter of reservation.
The booster point is still up. The booster point is up.
Then why there is an issue that if EC is not available, then it will go to B?
Yes, because there has been occasions where the candidates were not available in this category.
In EC category.
So, the High Court administration has framed a rule that if you don't get EC category, suitable EC category, then these posts will be given to OBCB because they are not a subcategory of OBC. So, the quota doesn't get diluted.
No, but otherwise, we have understood. But otherwise, if a particular recruitment process contains seats for both categories, which will prevail?
For both categories, then both categories will be there.
They'll be considered together. So their merit will be made a composite list, and from that, so they have separate reservations.
They have separate reservations.
Oh.
And separate roster points.
Okay.
So, but OBCB,
Although they are of the same category, there is a different roster point based on this exemption, which is granted for something in lieu of which they have done for the state. So BC is actually bifurcated into two kinds of.
bifurcated, or rather this is a subset.
No, because A is also having EC category.
Also has the same thing.
Therefore, we are saying BC is bifurcated.
CA or OBCB both have an exempted
Category.
Both have. And this is criteria is the same.
It is circumscribed by the number of vacancies available for BC. Within that BC, there are four, but none is given preference above the other. Between these four categories, they will compete inter se for that. Okay.
Page 129. My lord, page 129 of the stay application, my lord.
No, then let him make the submissions. Yes.
Yes. But the employment notification your lordship has seen. If you look at
Yes.
page 50 to 54, this is the employment notification. In terms of the employment notification, Lord, was a merit list which was published. Your lordships may kindly come to page 55. Lord, the merit-wise, Lord, declaration, and Devashish Das, the lordships will find is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Number 10 from the top. And Sudipto Sheel is just 3 persons there. Yes. Now, your lordships will find that in the unreserved post, there was only one vacancy.
So who is the red petitioner? Devashish is the red petitioner.
And Sudipto Sheel has been apparently the first. Now, Lord, page 50 would show that there was only one post in the unreserved category.
Yes.
And therefore, Lord, when the merit list was published, when the select candidates list was published, which is at page 59. In the unreserved category, only this Kopil Goirago, he got, because he was number 1 in the select list, merit list.
And the merit list you just showed it's a composite, all arranged in order of merit.
Now, Lord,
Promotional post. Direct recruitment.
Result of selection. Yes. $127. This was issued to him.
my reference client is an unsuccessful candidate. Yeah, I simply unreserved. Was only one vacancy. Because number 1, he was given appointment. Now, so far as this document is concerned, this is dated 11th of September 2024. Now, in September, this writ petition was filed. 18 September 2020. My Lord, parity is the prayer.
Yes.
Please come to page 46. By directing the station high court repatriation to consider the demands of the petition made to the representation dated before addressed to the registrar original side and to take a final decision on the same. The petitioner reasonable outcome. Two, by directing the respondents to treat the candidature of the petitioner as an OBCP candidate and order for an appointment of the petitioner in the post of assistant registrar court recording High Court and Calcutta by converting his candidature as a petitioner is ranked higher than which the High Court administration are the principal prayers in the record. And the representation of September 2024, on which not the petitioner relies on for consideration, that is at 870. Paragraph at 874. For the post of assistant registrar court, High Court original site will be appointed at a scale of 8, minimum 57,800, such and such, with additional special allowance per month. The classification of speeds of a classification category for which the number of vacancies the applicant who is an OBCB candidate will not apply for OBCB because he does not have the exempted category EC certificate with him. Therefore, he has applied for the same post under the general category, unreserved, where there is only one vacancy. After the merit list was published on 14th August 2024, it is seen from the merit list that the applicant secured 10th position in the merit list, and according to the said grade, unreserved, the applicant will not be original site position in the panel. It's a OBCB candidate ranked as OBCB candidate got placed as OBCBs, where the final notification of the merit list was published on 4th September 2024. In the category of OBCs, preserved for them. Therefore, the final notification on 4th September will be to apply for the same post under OBCB category have been selected for the post of OBCB EC, where he represented himself as exempted category candidate in the selection. The applicant is agreed by the decision of the High Court administration. The third says that situation happened on 2nd November 2016 when this candidate. Percentage of reservation of SC, ST and OBC category A and category B can be made. So reserve points for SC, ST, EC, OBC category A, EC, and BC. Category candidates belonging to exemplary category candidates belonging to SC, ST or OBC category A and category B. For any such reserve point, the said vacancy shall be filled up by a non-exemplary category candidate belonging to SC, ST or OBC category A and category B as the case.
So as per the rule, then do gives preference to EC category? It is only when EC is not available that it goes to that is what we were trying to ascertain to begin with. The OBC category comprises of A and B. A and B also have EC category. So this OBC is to be filled up first by OBC A EC. If not available, then A. No, but we'll go by this rule. You also have to go by this rule. Where is that provision that there will be a separate roster point for EC and no, at the time of creating the roster point, do you specifically provide for EC and non-EC separately? Yes.
There are 4 rules. Schedule class, one schedule disabilities having low patient.
Oh, so the point is separate, but it has to be filled up by BC. So if EC is not available, then non-EC. That is the scheme. If there is, this is an acceptable position. We are only about the scheme. Yes.
What the rules? And this is what my understanding in the High Court administrations are listening.
But where is this specified that it has to be worked like this?
That is not the point that the government fixes and gives.
There must be something. There must be something governing this.
Of course, we can't. The High Court administration can't fix it at their own.
Therefore, we are saying no. Even if you fix it, it has to conform to the otherwise reservation policy. So the reservation policy, actually, I would like to see that also. Yes.
But not this is the advertised course.
All right.
Advertised course clearly specifies the category for which not the advertisement is.
Correct. Yes.
And what the rule says that if a particular category is not available, say for example OBC B is available, but OBC B category B C is not available. It will be OBC B. Or OBC A, which category is not available, it will go to OBC A, and so forth. That's what the rule says.
It has to, because otherwise OBC cannot be left vacant when there is an OBC available, and it cannot be diverted elsewhere also. So therefore, probably there is a provision that if they are not available, you fill it by OBC, but non-EC category.
Now, the lodges may also see the applications both by the petitioner and the private respondent. But first, the application, which is at page 111. will find that this is Devashish Lal, who has applied. Turn the page. There is a column. Says mention the category to which you belong. Unreserved. As you can see, common categories. But can you also see the next column which says whether belongs to the exempt category in place, mention the identity card number issued from the Labour Department, Government of West Bengal, etc. So far as direct respondent is concerned, is considered this application, which is for
Yes, we have seen what you are trying to say.
so the category was actually no biggest in the but not under the rule. He had taken a chance and he has been, so far as OBC B category is concerned, he was the first category. Of alternate that they have in fact, there were 20 OBC category of categories for that. And he was the first of the category. Fundamental issue is where to, because that would be allowed by the report, even at the final stage. Because he says that these applications should be converted into OBC.
Yes, we have.
47. This is the main relief claim, apart from consideration of its representation. The main claim is that this candidature should be converted to OBCB and it should be considered as an OBCB.
No, we understand what you are saying. How can a unreserved be treated as reserved?
Yes.
But the fact whether is there any dispute that actually he is an OBCB category?
No dispute. But what he applied.
So therefore, he is not an unreserved category candidate. He applied in the unreserved category.
But not having reserved category candidate. Yeah, having applied as an unreserved candidate, he cannot, whether he can ask for conversion of his application from unreserved candidate to the reserved candidate. That's the issue. But I want to cite the on this. Factually, these are the facts. Now, whether the main prayer.
But that issue we are not deciding today.
My contention is that the final relief can't be given. There can't be an intermediate.
But then then we would have to consider the final relief, which can we do this when you have challenged only an interim order?
Because not keeping the post vacant.
Yes.
Is on the premise that he has some right.
That's a prima facie formation of opinion. There is.
It's the law. Prima facie formation has to be on the basis of the existing law.
Why you have omitted OBCP everywhere? Why have you omitted OBCP everywhere? In the advertisement, in the form, why? When you mention OBCA, why don't you mention OBCB? Where have you said that there is no vacancy in OBCP?
Because the advertisement does not include OBCP. I can't go beyond the advertisement.
No. Whether it is an omission or it is based on an assessment that there is no OBCB.
Based on an assessment that there is no OBCP.
So it's not an omission.
Absolutely.
So in the advertisement, do you say that this will abide by such and such rule?
That is not.
So what we are trying to understand, how the candidate will know.
Because the rules of the High Court are on the website. If a person is interested, he could have a look at it. Number one. Number two is that let us say that by mistake he has applied for unreserved. Maybe he thought that I will on merit I will be succeeding, whatever. But the point is that once you are right, in a non-reserved post, even if you are not asked for at a later stage after the selection. In fact, if you watch it permits, I can show the judgments here. There is a recent judgment of our High Court and Supreme Court judgment. Here it says, hold on this same. Even if a reserved candidate applies for applies on an unreserved post, he can't ask for anyone.
No, there that is clear to us. You can give the judgments, but that is clear to us.
That not firstly, the order has to be reasonable.
Yes.
Please come to paragraph 2 of this judgment. Paragraph. Heard the counsel for the appellant and also counsel for the contesting respondent number 1. The first respondent submitted an application for appearing in the combined competitive service examination for filling up the various posts in the state of Jammu and Kashmir. The examination consisted of 3 steps, namely the preliminary examination, the main examination, followed by interview. The last date of submitting the application for preliminary examination was 16 March 99. The first respondent submitted his application in time, and in application he did not indicate that he was entitled to benefit of SRO 126 of 1994, dated 20th June 94, issued by the state of Jammu and Kashmir. Thereby, the reservation was granted to the residents of the backward area and the line of actual control. The preliminary examination result was published on 15 May 2000, and the first respondent qualified himself in the examination. Applications were called for the main examination, and the last date for submitting application was so and so. First respondent submitted his application, wherein he indicated that he was entitled to the benefit of SRO 126 so and so. The Appellant Public Service Commission considered the application for the first respondent and took a decision that he was not entitled to claim benefit of the reservation by virtue of SRO 126, as he had not claimed the same in the preliminary examination, and the respondent was not included as a successful candidate in the category of reserved persons who were entitled to the benefit of SRO 126 of 1994. Then the first respondent thereafter challenged the selection by filing a writ petition, and the learned single judge of the High Court of Jammu and Kashmir held that the first respondent was not entitled to the benefit of reservation based on SRO 126 of 1994, as he had not indicated in his application for the preliminary examination that he was entitled to such benefit. The writ petition filed by the first respondent was dismissed, and he challenged the same by way of appeal, and the division bench of the High Court of Jammu and Kashmir held that the first respondent
SRO.
reservation.
It appears from what you have read that probably someone who lives at the border area.
Backward says actual line of control, line of actual control, or back residence of backward. Can you logically find the para?
So it must hinge on a certificate. This status must be hinging on issuance of a certificate. It's not. No, he is claiming OBC B, not EC. No, but OBC B, whether certificate issued or not, he continues to be an OBC. But SRO will not continue as an SRO unless a certificate. It's just like those who claim economic reservation. Unless they have a certificate, they will not be considered as a beneficiary. That we have understood.
Division bench of Jammu and Kashmir had allowed the successful find from para 3, the second part, fascism B, just around fascism B, the notice will find that the first respondent hearing, in fact, possesses the subcategory, even before the date of advertisement. And that by itself did not disentitle reservation.
That was his submission. Oh, this, but the fact is, in this case, because I have just had the opportunity of going through it, he applied without SRO. He participated in preliminary as a non-SRO. He clarified, he cleared that level of exam as an unreserved. Then he got the certificate.
Oh, subsequent level we disclose the certificate. Subsequent. First paragraph.
Middle portion of placetum E and F.
And the line of actual control. The preliminary examination result was qualified himself in the examination. The application was called for in the main examination, and last date of submission application was submitted. And the first respondent submitted the application SRO was actually a selection by the government. This one which he declared this at the final examination, not at the preliminary examination. Now I see paragraph that's the operating part of this. We advance by two parties. The first respondent cannot be accepted as applied for selection as a candidate. In fact, of the of the itself is sufficient to treat him as a candidate not entitled to pass the preliminary examination and at the subsequent stage of the meal examination, he cannot avail of information.
On the ground, now please read.
That he was successful in getting the required certificate only at a later stage. The nature and status of the candidate who was applying for the selection. Once a candidate has chosen of category which he is entitled, he cannot later change the status and make pressure. The status as on the date of application is fine.
Correct. There can be no two opinions about
Qualification and production of certificate at a later stage would make him entitled to seek recruitment.
it. That's why we said this is on the premise. It is like an economically backward candidate. Their claim, their status hinges on the certificate. Whereas OBC, SC, ST, there are judgments. You must be knowing Ram Kumar Grijurai's case that it does not hinge on the certificate itself.
From the date of application, whatever status has disclosed, he can't ask for a change of that status.
That we have understood. That we have understood.
And this view has been followed by our 54 SCC online. Yeah, 6
Here before Yep.
Supreme Court judgment. But apparently,
have just placed.
paragraph 15, if your lordship looks at,
Hmm. Yes.
This clearly follows the other judgment. They also
Neither she claimed OBCB nor she submitted the certificate. Application.
upload the where that he has asked for the repetition in terms of where I asked. My submission is that this is the where. Sorry. There is no representation, there is no problem. But there is other where I asked.
Yes, you have placed that.
My submission, I say that interim order is unsustainable on the face of it.
And when the matter has been fixed?
Matter thereafter has not appeared because it has been directed to order. From the minutes of
Earlier, was there any date fixed prior to filing of this appeal?
affidavit to be filed. By 22nd, and the matter was directed to be listed on 26th.
26 November. When do you want to make your submission? All right.
My lord,
No, you were saying you wanted a day, therefore.
my lord, if I may permitted to, if I may also get audience, my lord, in this regard, whatever Mr. Kaur has submitted, my lord, just want to emphasize certain points over and above that, my lord, nothing new, my lord. My lord, before Mr. Bhattacharya starts, because he also has, my lord, before your lordship come to, if your lordship be pleased to come to the advertisement itself, my lord, which starts at page 50.
50.
50 of their stay application.
Yes.
Lord, page 50, under clause 1, the vacancies have been declared. Unreserved EC. As your lordship has observed, that OBC B was not there. Now, my lord, subject to correction, what I have understood from the reading of this thing, when it comes, the vacancy comes with a 100-point roster, which is in vertical in nature. Now, in that 100-point roster, there are demarcations of exempted category. Now, those exempted category, those stays in the vertical line, but also being placed horizontally, only for the purpose that if a person OBCB and OBCB EC, if a person is missing from OBCB EC, then the OBCB candidate can be filled in that place. So that's the horizontal vacancy.
That he has already submitted. You said you wanted to add
thereafter, my lord, page 51, upper age limit for the employees of the High Court, other courts and government who will apply through proper channel shall be 40 years. My lord, and condition that the candidate has joined his or her initial appointment prior to the age of attaining 32 years in terms of the provisions of West Bengal Rules 1981, which has been duly accepted and adopted by the High Court of Calcutta by way of an amendment dated High Court of Services Rules 1960, dated 29th of March 2013. That is the rule which the High Court administration relying on for the purpose of how the governance of this thing will apply, my lord. My lord, now why I have indicated or emphasized on this proposition, because there is a directive, if my interpretation, there is a directive of a person who is already under an employment with the High Court or by any other court, because the writ petition over here is already an employment under the District Court of Howrah, my lord, at that point in time when he applied, and that will be evident from the application which he has submitted. If your lordship be pleased to come to page 112, that forms part of the application of the candidate, my lord. 14, serial number 14, are you a government servant? There is an indication that yes. Despite he being a government servant, he somehow chooses not to apply through the proper channel. This is one. Secondly, going back to page 15, 112, forming part of the application of the writ petitioner. Are you a government servant under clause 14? There is an indication, yes. Secondly, my lord, going back to the notification itself, the advertisement, if your lord should be pleased to turn down to page 52, my lord. Look, under page 52 at the bottom end portion, essential supporting documents required, my lord, kindly appreciate that in this particular advertisement, no specimen form was given. So the discretion is with the candidate as to how to prepare the form and how to apply, but the essential ingredients under that form has been specified in the advertisement itself. My lord, the essential ingredients, page 52, 3 identical size photographs, 1 self-addressed envelope, 3 photocopy self-attested of documents in support of date of birth, 4 photocopy self-attested educational qualifications, 5 photocopy self-attested any certificate in regard to knowledge of the computer. Now, my lord, 6 is important. Photocopy self-attested of caste certificate in case of candidates desiring caste reservation. So there is an opening, to my understanding, that if a person have been given with a leverage that if you want to avail the benefit of a caste reservation, then he can apply and he is supposed to put in that particular certificate under which he is claiming his reservation. My lord, thereafter 7 is not that important, and thereafter, my lord, 8, in case of service under government undertaking, public undertaking, no objection certificate from the concerned employer. My lord, I do not know with deepest of respect whether that has been supplied or not, because this application as per apropos that is evident, my lord, this has not come through a proper channel. So I do not know without giving an application without a proper channel whether this particular clause 8 of the notification can be complied with or not. Lord, thereafter, page 54, submission of application. Application must be submitted in a closed envelope, mentioning therein the category and the post applied for, and on the bottom left corner, which shall have to reach. My lord, at the cost of repetition, I am submitting once again, my lord, there is no specimen form. So the discretion completely lies with the candidate who is applying over there. Now, my lord, in this particular recruitment process, altogether 50 number of OBC-B candidate applied, and that will be evident from the list. Out of those 50, 20 succeeded the second tier of the examination. So he is not the only OBC-B candidate who has applied and been given preference, my lord. So far as the OBC-B is concerned, he has been ranked as 14th at the top of OBC-B.
He is the topper in OBC.
OBC-B, my lord. He is the topper in OBC-B. My lord, thereafter, my lord, the representation which Mr. Kaur has already shown, I am taking your lordship back to the representation, page 76, the bottom end portion. Starting with, it's the third paragraph, starting with the what in the present representation, further facts need to be gone into while advancing the representation before the authority of the High Court that in an advertisement which was advertised having reference number such and such, a notice was issued for the post of ARCR High Court original site, wherein the OBC-B category along with OBC-B category had been mentioned, had been simultaneously notified. In both the category, there is a single vacancy to be filled up by the qualified category. The applicant and found to be placed in the vacancy of the OBC-B category, and he was shortlisted to be appointed for the said vacancy, but he was in the waiting list. The next page, the applicant submits in the said election process. Also, the High Court administration did not convert OBC-B EC category vacancy to OBC-B category, but for the year 2021 selection process, the same High Court administration had merged the OBC-B category with OBC-B EC category vacancy which was never mentioned neither in the initial advertisement nor in the corriendum to that effect. My lord, pause here for a moment, my lord. My lord, this is the actual factual, this is the factual matrix under which the case has been developed. The case which has been made out by the writ petition has been further emphasized by a supplementary affidavit which also forms part of the this appeal, my lord. In that supplementary affidavit, a case has been made out that see 2017 this writ petitioner was part of the one of those candidates. At that point in time, he applied under the category of OBCB. There's a vacancy of only one OBCB and there's a vacancy of only one OBC EC. Now, at that point in time, since you have not converted, that vacancy under OBC BEC has been carried out so far in this particular year, in this particular recruitment process in the year 2021. Now, I have been denied benefit over there in the year 2017, so I ought to have been given a chance over here under 2021, my lord, where I didn't even apply under the post of OBCB. So I am already surrendering my right, whatever has been accrued through by way of a caste certificate, and availing the caste certificate under OBCB. My lord, that is the case which has been made out over here, my lord. My lord, so far as the so far as the judgment cited by Mr. Kaur, my lord, there is a 2025 Kerala High Court ruling in recent times relying on 2005, and there are some other, my lord, I'd like to place. It's 2025 SCC online Kerala 4575. Paragraph 3 of that judgment, the learned counsel lordship has paragraph 3, my lord. The learned counsel Sri Nand Kumar, appearing for the petitioner, placing reliance on the judgment of the Apex Court in Khan Singh Yadav versus State NCT of Delhi, argued that the eligibility criteria must be considered as applicable on the last date of receipt of the application, and submitted that any relaxation would deny the opportunity to similarly situated candidate. He also placed reliance on such and such. Thereafter, my lord, the observation of the Supreme Court in Khan Singh was reiterated under paragraph 5, if I'm allowed to place paragraph 4, my lord. In view of acute problem of unemployment, whenever few vacancies are notified by a public authority, it is common that thousands of applicants apply for such posts. If the applicants are permitted to rectify applications after cut-off dates, the same would render the scrutiny process indefinite. In the course of such recruitment process, many persons, though they belong to OBC category or SC/ST category, might not have obtained the required caste certificate before the cut-off date. Such persons, being law-abiding and being conscious of the bar contained in the notification of the cut-off date, might not have applied seeking employment. In case the authorities start accepting caste certificates subsequent to the prescribed cut-off dates, whenever a candidate approaches the authority, the remaining candidates who had not applied would definitely be affected. If the applicants are not allowed to submit the candidates in proof of their claim reservation subsequent to the notified cut-off date, it would create administrative chaos, my lord. This is what has been fallen from your lordship. What is the cases where the certificate has not been issued, similar to 2005 Jammu and Kashmir, my lord. Now over here, my lord, in reference to this particular case, the certificate was already there with this concerned person, the writ petitioner. He chose not to avail, my lord, and thereafter, my lord, paragraph 6. On the same judgment, the learned counsel for the 7 respondent, Minusha, relying upon the following judgments of N. Babu such and such, argued that the inclusion of the community in the reservation list is to undo the historical injustice, and such inclusion is only a declaration of the historical fact and is in nature of a restoration of the benefit. Therefore, the denial of a reservation would be unjust. Further, placing reliance on Dr. Rajesh Kumar, the learned counsel argued that the reservation applies at the time of appointment and not at the time of the application. My lord, thereafter, paragraph 9. Here, in this case, the issue is totally on different consideration. Article 16 of the Constitution refers to equal opportunity matters of public employment. There will be
six of the case that you are relying upon. The reservation benefit which the petitioner was claiming, that was not a reserved category till the date of issuance of the advertisement. After the advertisement was issued, that particular caste or community was declared reserved. Therefore, this is a
My lord,
totally,
why I am placing this thing, my lord?
the date of advertisement is 30th August 16.
16, my lord.
And this Mukhari Mubari community has been declared as a beneficiary of the reservation in December 18.
Request
How
of
can it
respect, my lord, why I am placing reliance on this particular judgment? Because first
It's not
of
a
all, in
case of the
2000,
person having that status on the date of advertisement and then changing? She never had that status.
my lord, kindly bear me for a moment, my lord. Paragraph 10, that 2005, what Mr. Kaur has relied upon right now, that 2005 of the Supreme Court has been
We have
relied on.
done that already. How many times?
And my lord, on the at the last fag end portion of that particular page, my lord, in such circumstances, the observation cannot be claimed retrospectively unless the rules enable it. My lord, over here also, similar case. The rules
That's why we are saying here it is a case of retrospectivity. This is not a case of retrospectivity. This person was already belonging to that community. Here, that community was not beneficiary of a reservation on the date of advertisement. There was
my lord, and so that's all, my lord.
the roster point is there
Page 129.
at 129.
Lord, that forms part of the rule itself, my lord. Lord, that
So this clarifies that the point for B and EC are at different points. But how? But it is interchangeable by virtue of that provision that you read, subject to availability.
Different vacancy label. But interchangeable.
Is it difficult to get that provision regarding EC? Yes, that I would like to take this opportunity to familiarize myself with that concept. Therefore, I am saying, if you can, then please. If it is too difficult, then we need not. Yes, yes, must be there in published. Yes, yes, so that we are in a better position to assess the situation.
Actually, right through this notification, it gives an insight.
Yes, at serial 9, you see what it says.
my lord, one more, my lord.
And then at serial 19, 9 and 19. 9 is non-exempted and 19 is exempted.
9 is OBC category.
Non-exempted and 19 is the exempted. So they have different roster points. But then the rule says that if it is not available, it will change. It will be made available to the other.
Can we get carried over? Adjust it. I'll check out. I'm also not.
We'll trouble you for one day.
My secretary, this will benefit me also.
Yes.
Kindly give me time till Monday to hand over.
We will.
My lord, one more important, page 60 of the stay application, my lord. The person who has been appointed, given appointment under the category scheduled caste EC, Geeta Biswas.
60.
Page 60. Page 60 is the final list of appointment, my lord.
Yes.
Lord, the name of the person appearing under the column scheduled caste EC, roll number being 282. My lord, kindly my lord, this is SCEC. My lord, what I have acknowledged, what I have obtained knowledge, my lord, this candidate also belongs from the category of only scheduled caste, but EC was not available. So similarly, she was also converted from SCEC to from SC to SCEC.
She was not converted. She was appointed against the vacancy for
Against the vacancy.
She
my lord. I
cannot be
stand corrected,
converted.
my lord.
Yes. Should we hear you today, or when we have that provision, we'll hear you? It's missing from your brief. What is that you're
Very important. Applied for. And this is for a page.
This is a more legible copy, yes. Yes, much more legible. Because in the one which has been annexed, we cannot find the marks. Or the rank is not, we have to. Yes. Why don't you give a better copy to Mr. Carr and the other council also?
Yes, just a one. I just had it.
Oh, this you have provided.
Yes. Okay. It has come like that.
Yes, because it's shaded. Once it is shaded, it will get darker in the copy. So now we have this also. So you may, but we are making it clear. I would like to see that. So you may, if you want to proceed, you can proceed today, or you will give it on Monday. We can keep it on Monday, or we should keep it on Tuesday. Maybe, yes. Change.
Yes,
My lord, that has to be changed, my lord.
from the tender number, it becomes a regular
A
number.
regular appeal, my lord.
আর প্রথমটা সার্ভার চলে যাবে। There will be two separate orders.
Appellate sir, item number 13.
তারপর তো বুঝতে পার হ্যাঁ এটা আমার ওই তো
Yes.
My lord, two WPSTs were preferred. One has come, that is WPST 174 of 2025 has come, but WPST 178 of 2025 has not come. My lord, these two matters are similar.
Let it be. Let us see what
My
happens.
lord, but the difficulty is this, my lord, in this matter, well, I'm led by senior advocates, my lord, they are unavailable today. So I'll be playing for a not today, my lord.
Not today.
My lord, let it be on Monday, my lord, along with both the matters.
Not today. Let it come tomorrow.
My lord, may I give the other matter number?
No, we'll see when it comes.
Similar matter, my lord.
Why it is not on the list?
I do not know, my lord. It is 178, but 180 of 2025 is appearing in the list.
List along with 178. We are informed by the learned
List
advocate.
with 174, today's matter.
26 Item number 15.
Item number. Well, there is a statement from my client that the issue may be resolved within 3 days amicably. So my lord, kindly send the matter in the month list of September. In within few days, my lord.
ডায়েরিতে না ওই না ট্যাগ করাই হয়ে গেল ঠিক আছে
Lord, my client directed me that kindly the matter may be amicably settled within few days.
How it can be settled? There is a disciplinary proceeding against you. How it can be amicably?
This matter will be dissolved, my lord. The proceedings are starting, so they called me.
If this matter is still pending, then why have you filed the writ petition?
Actually, I am led by Mr. Indril, senior counsel. Mr. Indril, senior counsel. Another court in another matter, he is engaged, my lord.
For setting aside the charge. Ask him, where is he?
Engaged in another court, my lord. Paying for not this one.
No. Ask him to come. Tomorrow we'll keep it. We can keep it on Monday. Adjourn motion on Monday. Yes.
এন্ট্রি লেখা থাকে Sixteen.
Lordship, the advocate for the petitioner is not present today. Lordship, I am humbly seeking for an accommodation, just to, not today. Deeply obliged, Your Lordship.
17. Hearing.
Who represents the writ petitioner? Not today. Hearing matter.
এন্টি বলে থাকবে কাকে কোনোটা তো এন্টি না ষোলো এন্টি 15 এন্টি Yes. Now,
Tribunal.
My lord, appellant, my lord, Mr. Shankar Prasad Dolapati, appear on behalf of the appellant.
Ask him to come.
Praying for not today, my lord.
No, sir. 2013 matter. Just see the number of adjournments. Ask him to come. Hey, where is the memorandum? Memorandum. Where is the memorandum? Yes.
এইটাই তো
Nice.
মিটিং করছে তুই রাখ রাখ, এখন মামলা করবো না, তুই রাখ। My lord, may I be permitted to say, my lord? Sir, I am busy in our meeting, my lord. What's happened, my lord, or one of the learned advocate, perhaps that advocate appeared before your lordship so many times, Mr. Manujendra Narayan Rai. He had been mercilessly beaten up by the police, and yes, and pelvic bone is fractured. Now he is admitted in hospital. 5 to 6 hours operation is required. Therefore, I got complaint from our members. I call urgent general body meeting, my lord. I rushed from the meeting to your lordship's court. Now I met with our Chief Justice, and the resolution is taken by our members that from tomorrow, from 10:30, the members will not participate in any judicial proceedings, my lord, till the two police personnel is booked, or the step is not been taken against them. It is informed to our Honorable Chief Justice. That is why at the time of call, my lord, I failed to appear. Kindly, my lord, adjourn this matter, my lord. Next week, my lord, this is last chance.
We are not recording any order. It will remain not today. 2013 matter.
My lord.
On Thursday.
Sorry, I am tendering apology, my lord.
No, it's all right. 13 matter, and Thursday is the hearing day now.
Yes, my lord, next Thursday.
Or 2 days we have not passed any order, but this can't continue like
My lord,
this.
sorry, my lord, I am, because I rushed from the meeting, my lord.
All right. So not
Sorry,
today.
Sorry, my lord. Next Thursday, my lord.
Yes, all right. So where he has
Municipal Hospital, Milord, in Salt Lake A block, he is also son of Justice M.N. Roy, who also the judge of this former judge Gonen Rai, and Chief Justice of this court. Subsequently, he transferred to Allahabad High Court. Milord, the oh.
18.
Like to
But it appears from the Malutta instruction that there is a miscalculation. The petitioner is that's not the verified truth.
That is why we framed the question.
The calculation was 90% Malutta. They actually from this instruction it appears Malutta the last drawn salary. Last drawn salary of the Malutta system employee and the family income was less than 90%. Accordingly, Malutta has because he is entitled. That is the Malutta instruction.
Yes. For appointment. Have you served on the petitioners council? No, he has to be considered because now he is eligible for consideration for compassionate appointment. But how he will know when he is not here? Members? Please inform us what is the situation.
That incident below, all the members are requested to attend court number 35, where the complaint was lodged before the court. That's it. 4:30 at 4:30 the argument regarding this. And issue will be that brought to the notice of the court to take action against the police. Within number 4.
Pursuant to its position.
তাকাও না। Item number 20, 19. 475.
Sushmita Shahadatu is appointed to the Union of it is very close. Praying for all this.
These matters were earlier taken up. Yes, okay. This was second. Not today. Not today. Let's call the list.
2021.
On behalf of Union of India, paid by my senior Mr. Singh, he is engaged in another court, your lordship. I'm praying for not to delay.
22. 23. 24. 25. 20. 25. So 18.
Let the petitioner be here. Call the next. Let's see. Nobody is appearing. We have just been informed that there is some issue. We don't want to record that there is nobody appearing for the petition. Yes.
27. 28. 29.
29 I appear for the applicant respondent. It's a appeal filed by the railways.
My lord, I'm praying for not to.